I do apologize to the court for that sort of wending way of the pleadings. But if the court, I'm getting indications that the court is appreciative of how the pleadings are then going to work. I'm indebted to the court. My Lord Presiding, members of the court, may I just take a step to say the following about the history of this matter. What the court will obviously know is at the time when my clients were suspended from Parliament, there was a single party majority that controlled the structures of the House. That was the ANC. That implicates squarely the principles set out by JAFTA in EFF 2. I don't know if it's helpful to take the court to that in the authorities bundle. Perhaps I can give you the reference. And maybe what we can do is if I can ask the court to take a note so that when the court then looks at this, when it has the bundles, the court will know it appropriately. The relevant paragraphs in the EFF 2 matter, which EFF 2 matter, citation 2018 volume 2 SA 571 CC, which I will refer to in these proceedings as EFF 2, the relevant paragraphs are 192, 193, and 194.
You're too fast there, Counsel.
I apologize. My lady, what may I assist with, the citation? Or the
page.
Oh, no. The citation is EFF and others versus Speaker and others, another, 2018, volume 2, SA 571, in the Concourt, paragraphs 192 to 194, and in the authorities bundle that we will make sure the court has copies of by the end of proceedings, the internal numbering of the authorities bundle we handed up is pages 204 to 205. And
this is the case dealing with the question of the motion, the vote of no confidence.
No, that was the impeachment proceeding.
This is the impeachment.
That's the impeachment proceeding case. Yes. And the reason I highlight paragraphs 192 to 194 is because JAFTA-J recognized the tyranny of the majority inherent in a committee system that is determined in Parliament by means of proportional representation.
Now, the question I suppose we're going to have to debate is whether the factual context of that particular case is equally applicable here.
With all due respect, my Lord, it is the underlying facts of that case are not necessarily directly on point, because you'll remember in the history of that case was at a time when there was no specification in terms of how the Section 89 motion is brought.
Exactly, there was nothing.
Correct. And what we say is that the principles recognized in the court and the way in which the majoritarian system works in terms of committees applies a fortiori to this committee, because this committee, before this current election that we've just had, was constituted by a single majority. So the principle of the tyranny of the majority, which was prevalent under the Section 89 regime, is as applicable here in the context of how the committee discharges its function. So, here's where the facts become interesting, because with all due respect to our learned friends from Parliament, they invent a red herring case, and then they impose that case against my clients. Because how they construct the case is they say, we want to externalize the entire disciplinary function of the Privileges Committee to some independent senior legal practitioner.
That's not what you're doing.
No, that's not correct, my lady. Why it's not correct is because we say the fact-finding portion of a disciplinary proceeding should be externalized to a senior legal practitioner or a judge or someone of equal status, because that provides an internal check and balance.
There are a lot of jumps in this logic now, so let's just start from basics.
Yes.
In the EFF2 case,
yes,
which I read it carefully, you tell me, which will be helpful, as to how you can see what was the problem in that case.
So if we look
what
at
was the problem in that case?
If we look, may I just summarize what 192 says, because I think the more helpful paragraphs are 193 and 194.
I'm happy for you to do that, but I still want you to tell me exactly how you read the facts of that case. Let's start there. What was that case about?
I think we've already agreed, Justice Davis, that case was about how the Section 89 inquiry proceeds in front of Parliament.
Why was there a problem?
The problem is this. 192, the Constitutional Court says, a decision by members of the majority party and the ad hoc committee may prevent an impeachment process from proceeding beyond the committee to shield a president who is their party leader. Surprise, surprise, look what happened in Pala Pala. In recognition of the point that impeachment proceedings are partisan, the acting speaker averred the initiation of such proceedings is inherently partisan, as the aim from the outset is the removal of the president, who will almost always be a leader of the party represented in the assembly.
Yes,
now,
I understand that, but you see, you're taking this out of context, because have a look at 196.
yes,
I conclude that 89 implicitly to make rules tailored for the impeachment process.
I'm sorry, my lord, could you repeat that?
196.
Yes,
That's what this is all about.
Yes.
What it was about was that you didn't really know, what were
Yes.
the criteria
Yes.
for impeachment.
yes,
Therefore, you couldn't just have some kind of unfettered discretion
Correct.
in that regard.
Correct.
And you needed to have some mechanism.
yes.
Yes.
And-
But that doesn't, non-constat, that means that all of a sudden we can therefore conclude that this is authority for the proposition that when Parliament has to discipline
Yes.
its members,
Yeah.
somehow you use the same logic there. I
No,
don't
no,
see
no.
how that follows.
That's with all due respect, that's placing my client's case higher than what it actually is. Because what my
Tell me why.
clients say is this, is that this is authority for recognition of how the majoritarian system operates in committees on the ground. I accept that what Justice Davis says to me about the fact that that was at a time when the Section 89 process was not clarified in terms of the rules. I'm not suggesting that the facts are necessarily the same that I'm relying on in these proceedings. I
They're
can't.
not, yeah.
Justice Fortain shakes her head at me and I'm agreeing with Justice Fortain. The facts are obviously not the same.
And
But
therefore, where does that take me?
but the point is this, with all due respect. Look at what happens after this judgment is handed down and the process that Parliament adopts to vindicate the impeachment procedure. What we know from the impeachment procedure is the first step when a Section 89 motion is tabled is it goes before an independent impeachment panel. And that impeachment panel conducts a fact-finding exercise to reach a position of whether or not the President has a prima facie case to answer, and thereafter hands over that prima facie case to Parliament to run its process in terms of the partisan system which we find ourselves in. That's the point we're making. The point we're making in our case is not that Parliament must lose its ability to discipline MPs. Of course it must have an ability to discipline MPs. But it's about the ability to discipline MPs stemming from an impartial fact-finding mission, which then determines the scope of the inquiry
You see, that's
and
where-
the role to be played by the
that's where
committee.
That's where the logic is problematic, because in the case of an impeachment inquiry, remember the Constitutional Court said you've got to make rules for this.
Yes.
There's authority that it has to be an independent person.
No, I'm coming there to demonstrate why why an independent practitioner is the most appropriate way
It
to
may
do
be,
so,
but
relying on the
there's no
logic of this
authority in
case.
that case for that particular proposition.
No, there's a novel proposition in front of this case in the context
that's
of
number one. Number
privileges.
two is there a difference between an impeachment of a president and internal disciplinary procedures insofar as members of Parliament are concerned?
We would
Or
say
is there no difference?
No. We would say that with all due respect, engages the wrong question. It's not about the identity of the official who's being held to account. It's the system in terms of which the official is held to account, and whether, if I may finish the submission, that is open to potential abuse by a majority constituted along partisan lines.
Well,
if I may finish the submission,
yes,
please.
make it.
The point is that Parliament can discipline its MPs, that's fine. But absent an internal check and balance to ensure that it is simply not being done along partisan lines because the power rests with the majority on the individual committee, is where the potential for abuse arises. And may I say this, the way in which you fetter that current unfettered power in the hands of the majority could take the form of an independent senior legal practitioner, or it could take the form of guidelines. If the schedule had enumerated guidelines to say what an appropriate sanction is and how you consider Section 12.9 of the Act when read with Section 12.5 of the Act, then that would have the impact of reducing the ability of the committee to simply run roughshod over everyone's rights.
We'll get there. I'm just simply trying to establish precisely what use I need, speaking for myself, to place on this judgment that you cited. All I'm saying is, there seems to me to be an extraordinary difference between the impeachment of a president, which would ultimately mean his removal or her removal from office, and somebody who's suspended for a period for want of compliance with disciplinary procedures.
With all due respect, Justice Davis, that again prefaces the preeminence of the president as against, for example...
It's the question, sorry, with respect. It prefaces, it's the preeminence of a removal from office.
Yes.
That's a massive step.
I'm with you.
Right? There's a difference between that and saying you'd misbehaved, therefore you are...
No. What the similarity is between the two is it depends on the political influence and the ability of the majority to control the votes on the House.
So your point is simply this, that what this is authority for is the view that if you just leave it in an unfettered way to the members of Parliament, that effectively is susceptible to abuse. Correct. And that's all you say.
It's no higher than that, because so that's the perverse incentive structure.
So let me then ask you a second question, nice short-circuit this. This argument's been tried before in front of a full bench of this division.
Judge Lord was decision.
Cloama, I believe.
Yeah, Mr. Judge Lord.
The Cloama matter.
Yeah. Tell me why that judgment is palpably wrong. Because if it's not palpably wrong, I'm obliged, speaking for myself, to follow it.
In the first instance, Section 12.5 wasn't placed in dispute in those proceedings in the way it is frontally challenged here.
Well, that's very, very dancing on the head of a pin. The fact of the matter is that that court was asked the same sort of questions about bias and majoritarianism, and it found that that wasn't the problem.
Sure, but then the Constitutional Court delivers EFF 2 in 2018, 2 years later after Cloama, which casts a completely different light on the way in which majoritarianism works in Parliament.
So your argument is that it certainly didn't overrule that judgment. That judgment's still binding on us, unless we say it's palpably wrong. And if it's palpably not palpably wrong, what are we doing here? I mean, that's the precedent. I take the point. You've got to tell me now, the one thing you told me is it's distinguishable. Is that what you're trying to say?
Yes, 12.5 and the frontal challenge and the frontal constitutional challenge.
It would be very helpful if we got past that point before we got any... Would you agree with me that if you can't persuade us on that, then that's the end of it?
Insofar as the constitutional relief is concerned, yes. Insofar as the review relief, the review relief is separate. Yes.
Now, only in relation to your prayers with regard to the constitutional relief.
Yes.
We have to find, one, it's either distinguishable, or two, palpably wrong. Would you be... I'm just trying to get the menu, that's all.
I accept that.
And that's where we want to start.
Yeah.
Yes.
Okay, so let's have a look at that.
Yes.
I want to just get my judgment.
Can we look at that copy of the amended notice of motion
that
I handed out?
Yes, please, absolutely.
Thank you.
I just want to get there. Oh, sorry.
It starts after paginated page 3 of the filing page.
Drowning in paper. Yeah, sorry. Please carry on.
So it starts after paginated page 3 of the filing sheet. Yeah. There are about 4 or 5 pages which have been struck through because that's part A.
Part A.
Yes? And now we're in part B.
Yeah. Paragraph.
Paragraph 6, starting under part B.
Yeah.
So, on the question of whether if Cloama is binding on this court, what would it strike against? It would potentially strike against 6.1, because that's the impartial fact-finding mission, bias, majoritarianism, constitution of the committee.
Absolutely.
Okay? 6.2 is open for me to argue, because Cloama didn't deal with absence of guidelines in the context of sanction.
Okay.
Section 6.3 is still open to me because those are about
Paragraph
6.3. I apologize, my lady,
Yeah.
because those are about fair trial rights, specifically in the context of the right to cross-examine witnesses, discovery of documents, and standard of proof. 6.4 is still open to me because that's about a time bar. So if Klama is against me in the way that the court positions it, fine. I'm potentially in danger on 6.1. But my answer is 1, distinguishable, 2, EFF2. But
So-
if the court's against me, then 6.2 to 6.4 are still there.
So the substantive point is this, your submission, is that on 6.1, unless we find the judgment to be palpably wrong, that's it in relation to 6.1. Well, it must be.
If we don't, then it's
Unless you determine that it's distinguishable. Because remember,
Well,
I raised
don't see how to
distinguishability as a second leg of the argument.
Well, reading that judgment very carefully, that is the judgment Justice Lord. And by the way, on that Justice Bozalek agreed. Therefore, the question
Yes.
is, I don't see how you can. Because he talks about Rule 2, he talks about the fact that you can't delegate.
Yes, but
It's absolutely clear.
with due respect, there is no square answer on the frontal challenge then, because if you read 6.1 about the disciplining and independence, and then go over the page to 7,
Are you submitting that it's different?
yes,
Let's read. Look at paragraph 21 of Justice Lord Law's judgment.
Yes.
Tell me where on earth one can take a different. Of course you can.
which one? Oh, you have a copy of my bundle, I don't.
Thank you, Mike.
Thank you, Mr. Bishop. My Lord, yes.
Prepared, I would call that. Wouldn't you?
I beg your pardon?
Well prepared, I would call that.
Yes, and especially because it's my client's authorities bundle that was handed up,
Yeah,
which
really.
allows him to be so well prepared. So I take all the credit for that.
Very good.
Justice Davis, we were debating
Paragraph 21.
paragraph 21.
No, I'm just trying to sort myself out. That's fine.
Yeah, so oh, Justice Davis, may I?
No, you carry on. I'm listening to you.
Sure.
Yeah.
So, Justice Davis, I accept the point that you make if 6.1 was where the relief stopped in the notice of motion.
No. I want to make this absolutely clear. All we're talking about now is 6.1.
Yes.
Right?
Yes.
Your submission to me, which will Court Circuit, this is absent 6.1, that doesn't prevent you from getting other relief.
No. Yes, on the 6.2 to 6.4.
Yeah.
But what I'm saying is you have to read 6.1 together with paras 7 and 8 because of the same amended notice of motion, just for clarity. Declaring the impugned rules relating to these things to the extent they fail to conform with the requirements of 12.3, and then declaring section 12.5 of the Act as unlawful and unconstitutional. Okay, 8 is perhaps speaking to the guidelines issue, which is 6.2 and
Well,
6.3,
it does,
but
absolutely.
7 is the one where I would say gives us the ability to re-argue the point in respect of the relief in 6.1.
Because it wasn't dealt with in the judgment.
Yes.
The other one.
And certainly not in the context of EFF2 talking about majoritarianism, which we say is admittedly for a different purpose, but on the role of the majoritarian nature of the committee.
The problem is that if you don't have an independent, if you can't argue that, then this whole question becomes inevitably, as your opponents would argue, that Parliament must deal with it itself. If they can't outsource to an independent person, then Parliament has to deal with it. The committee will be a committee. By the way, I mean, it's rather funny now because given where we are at the moment, as you well know.
Yes.
It just shows you
Yes.
that things are so context.
But that's perhaps where I think we should locate this portion of the debate, because the nature of the majority in South Africa at the moment is a volatile one.
Yeah.
And the point here
Yes, I agree with you on that.
point here, I mean, we don't even...
There we are, actually, it is.
We don't actually even have a majority at the moment in South Africa. That's how volatile it is. But
Yes.
the point that I'm making
Yeah.
is that then
It would be a great
triggers...
time to have this. Yeah.
That then triggers the underlying debate, which was foreshadowed in EFF2, because this then becomes a debate about what kinds of safeguards are there for MPs, and particularly opposition MPs, when they might be subject to the disciplinary powers of the majority, however constituted. So the point is that particularly following on from what the Constitutional Court says in EFF2, admittedly different subject matter in terms, but when it is analyzing the majoritarian nature of the committee, is what this court cannot close its eyes to. Because that at the very least is persuasive to invite this court to reconsider what the full court in Tloama determined in the context of the kinds of protections that MPs deserve, and the tyranny by the majority that the Constitutional Court recognized.
Can I just ask, well, let's assume that we can't deal with the question, sorry, let's assume for the purpose of debate that Justice Lordlaw's judgment in relation to
Yes.
is correct, right?
Okay.
But then your second point is this issue of the majority.
Yes.
How do you then deal with the problem that the Constitutional Court, I think in one of the Democratic Alliance cases.
Which one? There are many of them.
I know, but I'm going to give you the point.
That's Mr. Bishop's fault.
I'll give you the point. The point is that held that members of Parliament owe a greater fiduciary duty to the Constitution than they do to their political affiliation.
Yes.
Well, that means that what the Constitutional Court says is their primary obligation
Yes.
is to the Constitution and the inherent nature thereof,
Yes.
not to their political parties.
Yes.
That by the implication is obvious, that when they sit in this particular regard,
Yes.
their primary duty is to actually act fairly.
Yes.
Not in terms of their political party.
Yes.
The Constitutional Court has preempted your argument.
With all due respect, the Constitutional Court has laid down the foundation for this court to support my argument, because that's
Sorry.
the point. The point is that when the Constitutional Court can say, for all it wants to say, that MPs have fidelity to the Constitution first and their party second.
That's their obligation.
Yes, but EFF2 recognizes that the facts on the ground are hardly ever like that, and that is inherently linked to the question of the majoritarian system in which we find ourselves. Now, I'm not saying, if I may finish, I'm not saying that the majority must lose in its entirety its ability to perform as the majority, because that would be the kind of outsourcing that
Within the Constitution.
Yes, because it's obviously the majority's conduct is
Same
subject to
rule.
constitutional constraint.
Same rule.
Exactly.
Yeah.
So the point here is that if the case is not that it's an entire externalization and outsourcing to a third party who must then make a determination of innocence or guilt. That function, the actual value judgment on innocence or guilt, can remain with the majority.
But if they
It's
don't-
about.
If I can just say this, they can't, if they don't follow the constitutional precepts, then they're not acting legally.
Yes, and that's the
But
point
that's-
that we're raising here.
No, that's the point. That's the point about whether, in fact, in this particular case, they actually behave that way, not in principle.
Well-
the principle is against you. The application of the facts may be for you on that particular line of argument.
Yeah,
And the further problem that you face then is the rather strange situation that what you can't argue, and you haven't, is that at the end of the day, Parliament votes on this, votes on recommendation. So frankly, sorry, what does that then mean? That means at the end of the day, Parliament actually decides whether somebody should be suspended or
Yes.
not, and they do so
Yes.
politically on your line of argument. And
Yes.
there's nothing, you're not challenging that.
Yes,
and
but
you
that
can't.
no, I can't and I won't, because that would fundamentally serve to denude a legitimately elected majority from the powers afforded to them in terms of the Constitution. That's not controversial in this debate.
But let me ask you this then. Would you accept that despite what the committee may do, Parliament could vote that down?
In theory, yes.
What do you mean in theory?
In theory, because EFF tells you that when impeachment motions, which are quasi-legal in nature, come before the House, the incentive in the way Parliament is constituted is to undermine a proper case that would demand impeachment, because the majority acts to protect itself. The point is, and I think where we are slightly speaking at cross purposes, is that the court must disabuse itself of the notion that my clients are suggesting that the majority cannot exercise the powers lawfully ascribed to the majority. What this case is about is the process of how we get there. And we say if the majority will operate to fetter the possibility of political abuse already recognized in EFF2. The first one is you outsource the fact-finding component of the case.
We've already got to the point that unless you find that that's wrong, we follow that.
You got the point then. Then the second
point would have to be this.
Yes.
It would have to be what you say is if the committee has to deal with this, it should have clear guidelines.
Yes.
Which would essentially constrain it.
Yes.
Is that what you say?
That is the constitutional constraint.
And
yes,
your submission
absolutely.
would follow, as I understand it, that because of your concern, as you've articulated, that you could be subject to majority abuse
yes.
if that doesn't happen, and if you can't outsource because Parliament must discipline its own, then at least there should be rules which constrain the discretion.
Correct. We are ad idem then.
All right, let's move on, because we
Yes.
understand your submission.
Thank you. I'm indebted.
Yeah, whether I agree with it is another matter, but the point that I understand.
I mean, I'm just pitching a
Don't be
bit...
indebted too quickly.
I'm pitching a bit lower than that. I'm just indebted that now I understand my submission too. That being the case, though...
Well, I'm delighted that you do.
I mean...
you get paid a lot more for this than I do.
I take all the guidance I get from up above, and I'm open to it.
Carry on.
So, we... putting aside the Floyd debate, you've got my submissions on 6.1.
Yes, I have.
Yes.
Thank you.
Yes.
May I then just talk briefly about 6.2, if that is applicable?
We're following an amended notice.
I think in light of the way in which the debate has happened in front of the court, it might be more appropriate to do so. I've prepared my own submissions with a different structure, but
Keep going.
I think the nature of the debate is such that let's just take it on the hoof as we are. So back to 6.2. They failed to provide sufficient guidelines for the exercise of the discretion insofar as sanctions are concerned. I don't know if the court has available to it the Act and the rules of Parliament together with the schedule. I'm just going to ask my team if I can get the relevant references in the record,
Yes,
because I think it's
It's
helpful.
in the record somewhere.
Yes, yes.
I've seen
May,
it,
may
yeah.
I take a moment?
No, yes, please.
Thank you.
No.
May we go to paginated page 75? I apologize to the court. I'm supposed to have
that's fine. Don't worry. I
a
understand.
stowaway, and I don't know if I've got a stowaway. Hallelujah. If the court will bear with me whilst I organize myself. Yes, so paginated page 75 is where the rules start. It's labeled Annexure FA0.
Just let me get there.
Thank you.
Yes, got it.
Could you please turn along in that annexure to paginated page 81? I'll be with the court in a second. My Lord, I'm told that there is not a full copy of the Privileges Act in the papers. So what I propose to do for the purpose of this argument at least is to refer to it, and we'll make sure that a copy finds its way to you,
Yeah.
if that's all right.
May I be of assistance? I have copies for the court.
But not for me, unfortunately. So that's also a part of
Now,
it.
I will be of an extra
there
assistance.
you are.
For my learned friend as
I'm
well.
indebted to Mr.
You
Nasseruddin.
see, if everything was as collegial as this, we wouldn't have been here today.
Yes, my Lord, but that's because we're advocates, not MPs.
And we're not in the majority, but there's two of us.
Never going to be at the rate we're going.
That's why a time bar might be appropriate, my lady, but I'll develop that submission just now.
Okay, so now are you going to refer us to this one, the Act?
So can you
Shall we
keep...
use that one?
No.
No,
Hold
you
on.
want-
We're talking about
where are
two
we
different
back to where
things.
are we still looking at the rules?
You're
The
still
rules.
looking at the rules,
Okay.
paginated page 82. Keep one finger there,
Yeah.
and then
No, it's 82.
82. Yes, my lady. At the top of the page, it should say penalty on the top left-hand side, and then paragraph number 9.
Yeah.
Does your ladyship have it?
Yes, we have it.
Thank you. Keep one finger there, please. And then in the act that was so generously handed up to the court and myself by my learned friend, please turn to internal page at the bottom right-hand side. You can see the internal page numbering. Section 12 starts on page 6. But the two sections I am relying upon are 12.5 on page 7 and 12.9 on that page 7 as well. So we're going to read them both side by side if you don't mind.
12.6 and 12.9.
12.5 and
12.
12.9. Does the court have the
Yes,
relevant
yes,
things?
Yes, we do have it.
Okay, let's start then at paginated page 82, penalty. Because all the penalty provision says the following. If the committee finds the member guilty of misconduct or contempt, the member, fellow member, or legal representative must be given an opportunity to present mitigating factors. We don't have no indication what those mitigating factors could be, to the committee before the committee reports to the House. Such representations may be verbal or in writing. The initiator may also address the committee on aggravating or other factors. That's all the schedule says insofar as the committee, because remember the committee has to recommend a sanction before it then goes to the House, which adopts the report, and then the sanction becomes implemented and imposed. That's the structure and the relationship between the schedule and the Act. Now, we can put the schedule to one side for half a second. Look at what 12.5 says of the Act on page 7. When a House finds a member guilty of contempt, the House may, in addition to any other penalty to which the member may be liable under this Act or any other law, so that's about other penalties, impose any one or more of the following penalties. And then you have an enumerated set of penalties. And then you have to read that simultaneously with 12.9, because remember, my clients were suspended here for the maximum of 30 days. Before, and this is what the Act says, a member at 12.9, a member may not be suspended under 5G unless the House has found that the member is guilty of a serious or repeated contempt, and this is a conjunctive reading of the clause, not a disjunctive one, none of the other penalties set out in subsection 5 will be sufficient. Now, there is a dispute between myself and my learned friend as to whether or not that 12.5 and 12.9 inquiry was ever done, but that's more along the lines of the review relief. I'll come there later. Let's just talk about the principal issue at the moment. The principal issue at the moment is that if we look at the penalty provision, which I referred you to on page 82, there is absolutely no guideline as to what an appropriate penalty could be, how the adjudication function is supposed to happen in terms of section 12.9, where one of the other remedies or penalties are inappropriate, how much weight is to be attached to mitigating factors, how much weight is to be attached to aggravating factors. whether, for example, and we know that courts do this all the time. For example, in declaratory tests, you know, on the second leg of the discretion that the court is afforded, there are a bundle of factors that the court takes into account before granting relief, including things like delay and practical effect and so on. Sorry, Justice Ntsimini.
Won't those come out from the mitigating factors or the aggravating factors?
It may, but that's not an answer to the principal point. Because remember, that only occurs if any of the parties before the committee choose to raise mitigating and aggravating factors. So what we're saying, the principal attack on the Act and the rules as it currently applies is that there's absolutely no guideline and no guidance at all in terms of how the penalty power, which is a substantial power, is to be exercised by the committee.
Well, let's just look at this. You attack 12.5.
Yes.
It is significant that you haven't constitutionally attacked the other sections, but I'm not sure that leads us is relevant to the point you now make, which are guidelines.
Well, I disagree with your characterization, but I accept what you're telling me insofar as 12.5 is concerned. So yes, let's please carry on.
You haven't launched a frontal attack.
No, and because my clients don't need to, but that being besides the point.
That may not be. We'll
indeed.
have to come to that ourselves.
Absolutely.
Whatever your clients may think.
Absolutely.
The point I'm simply making in relation to 12.5, your point is this, stripped to its essence.
Yes.
Is that when it comes to actually the imposition of a penalty,
yes,
at that particular point in time, you want guidelines.
yes.
Right.
Both at the recommendation stage from the committee and then when it goes upstairs to the full House sitting in plenary.
Yes, well, they would, yes. Yes, okay. Now, 12.5 says, when the House finds a member guilty, in addition to any other penalties, and then it tells you there's a whole range. And then 12.9 says, you can't be suspended unless you're guilty of a serious or repeated contempt.
Yeah.
Yes.
So, that's the guideline, serious or repeated.
Well, what is serious, with all due respect, and which is the appropriate decision
Well,
maker
I mean,
in determining what constitutes serious and what doesn't? Leave repeated to one
It's
side.
factually dependent. I mean, you know, that's like saying what kind. I mean, it's the great debate we have about sentencing guidelines generally
Yes.
speaking.
No,
we
of course.
all know, we
Of
all
course.
know that it's extraordinarily difficult to specify that entirely. So, a serious one. I mean, let's assume for the purposes of debate
Yes.
that your clients had simply shouted from their seats.
Yes.
One would find that very hard to regard that as so serious as to be suspended
Well,
on its own.
I would be grateful if Justice Davis was an MP from the majority party bringing such a judicious mind to assess
I'm
the
not sure who
facts.
the
But as
majority
we know from
party is.
EFF
All I'm
2,
simply-
that's not the case.
But there may be a prospect of review then.
Potentially, yes.
What I'm trying to
Potentially,
say
yes.
is, yes, obviously no one here is arguing that there isn't some review power. The
Yes.
question is,
Yes.
what we're testing is serious would be has to be essentially at least articulated. So in this case, my understanding is serious is because your clients ascended the platform or the stage,
Yes.
and in the view of the committee, after evidence, they thought that was sufficiently threatening of the President and the Speaker and others
Yes.
to warrant a serious... Now, we could debate that.
Yes.
And you are entitled to say, you can't be serious. All they were doing was going up to give Mr. Ramaphosa a cup of tea because he was thirsty. What I'm trying to say, in short, is that factually dependent upon whether it's serious or not. I don't understand what further guidelines you want.
Well, I'd
be fascinated as to what guidelines would tease us out further.
And in essence, Council, aren't you really seeking to limit the powers? Because as they currently stand, they are wide.
Yeah.
Yes, but I think the answer, Justice Ntsiweni, comes from Darwood, which is at page 713 of the authorities bundle, and paragraph 47 in particular, where the Constitutional Court, admittedly in the context of an administrative function,
was about to say that.
but we say that the principle is nonetheless the same, where the Constitutional Court said, moreover, if broad discretionary powers, this is the point that Justice Ntsiweni raises with me, broad discretionary powers contain no express constraints, Those who are affected by the exercise of the broad discretionary powers will not know what is relevant to the exercise of those powers or in what circumstances they are entitled to seek relief from an adverse decision. In the absence of any clear statement to that effect in the legislation, which we say is the legislation and the rules. I'll finish, Justice Davis, and then I'm ready to take the question. It would not be obvious to any particular potential applicant, in this case, my client applicant, otherwise an MP, that the exercise of the discretion conferred upon the immigration officials and the DG here, we say by the committee, is constrained by inter alia the Bill of Rights and so on. So that's the point that we make about this debate in principle about whether serious, absent enumerated constraint is sufficient in and of itself.
You see, what I want to test with you is this is an Act of Parliament which basically says you may not be suspended unless guilty of a serious or repeated. We know
yes.
Repeated is pretty
repeated. I have no difficulty with.
The question with serious is, tell me what the guidelines would look like.
Yes.
I need to say, aha, I see what you say. I'm not asking you to draft me guidelines.
Yes,
obviously.
because that would be
No,
inappropriate for us to do. Absolutely.
But give us an example. I mean,
So-
this is what we...
no.
Yeah. What,
When you say, this is a serious offence, judges or parties, I mean, again, I come back to this. What would the guidelines add? Would they say jumping on the stage is serious, shouting is not? How would this work?
no.
Because I'm trying to get my head around what the guidelines would add, because it's central to the submission.
With all due respect, that is entering dangerously into the territory of us attempting to draft what those considerations would look like on the hoof here. And the reason I say that,
I'm not asking you to do that.
I'm glad you're not,
The
Judge.
question from the bench, because
Justice
my
Davis, I
sister asked the
apologize.
same question, is what we're grappling with is
yes,
how would guidelines constrain this discretion? What is it that they would add? And what would the guidelines look like in broad terms? You must have thought about that.
well, what we
Because
know...
let me tell you why. I don't want to give an order which actually is a nonsense. In other words, people
Fair.
say guidelines. What kind of guidelines are you
Fair.
talking about? Are you insane? What I'm trying to say is, I'm not asking you to tell me A, B, C, D.
Yes.
But what would they broadly look like which would essentially close the notion of serious in such specificity to meet your point?
No, firstly, it would, as a matter of principle, it would not have to be with such specificity to make
What's
my
the
point. Because,
specificity
no,
of it?
hold on, with all due respect, because...
What's the specificity?
Because with respect, what we know from the authorities around the fettering of discretion is it depends on the nature of the power that's being exercised and the kind of consideration that the decision maker has to make. It could be examples of seriousness. It doesn't have to be X, Y, or Z offences. And that's the point. In the absence of guidelines to otherwise qualify what might be serious is open to abuse. And that's what the court recognized in Darwood. It's also what it recognized in affordable
There's a very
medicines.
big difference between a discretion of an immigration officer and something of the statute of this kind. Again, I don't think it's a helpful use of authority, but let me put the same point to you again. The question is, when it comes to sentencing, it's always a question of in the eye of the sentencer. I mean, that's how it works.
Yes,
you
absolutely.
know that. You must have been in the magistrate's court sometime in your early career.
Sadly
That's how
not,
it
I
works.
must say.
So what I'm trying to say is, what is the difference? If it's serious, then if, for example, you came to this court and you said there is no way that any reasonable sentencer could have regarded what my client said as serious, we would have to apply our minds, and if you were right, we'd have to say, I'm terribly sorry, Mr. Malema et al. Have been improperly dealt with.
Yes.
That's the way it would work.
But that would be a reasonableness attack here. We are simply relying...
Isn't that precisely the point? You have to accept that the exercise of the power is reviewable.
Yes.
Well, otherwise we wouldn't be here at all.
Well, at least for the second bundle of relief that
No,
I'm
you have
asking
to
for.
accept
Yes,
it.
absolutely.
I'd be delighted for you to say there wasn't. 'cause I could
Review
go-
justiciability where ad idem completely.
No, because I'd be delighted if you said no, I could go home like that.
I could go back to Johannesburg.
But having said that, what I'm trying to say is,
Yes.
if it's reviewable, then surely to goodness, factually dependent would then mean if you as the House or the committee overstep the mark on the bias argument that you're saying, please come to court and we would correct that. What's
that's
so terrible about-
under your review power.
review.
That's
Yes,
under your review
yes.
power. What I'm saying, and I think perhaps it's appropriate to say that the supposition of sentencing is the inappropriate comparison, because that is about a judicial officer considering.
Well, this is a form of sentence, one way or the other.
Yes, okay, fine. But then what we know is that there are, firstly, judicial officers are not directly themselves invested in sentencing the parties appearing in front of them.
Yeah,
The
but-
structure of the committee is fundamentally different because your political opponents sit in judgment of you.
Well,
I'm not going to
that
rehearse what
comes
we
back-
discussed in.
Now
I'm
we're
not going to
going back-
rehearse what we discussed in the morning, but it's important for me to start there because it's a distinction about the function of the decision maker and who the decision maker is. That's the first point.
So, yes,
The second
what's the second
point, the second point, what we know in the context of sentencing is that there are minimum sentencing provisions and there are factors that are included in legislation that is applicable to sentencing, which either enumerate powers by means of illustrative example or contain specified and contained considerations that the judicial officer has to consider. I'm saying if we can accept sentencing as the equivalent paradigm, ipso facto the absence of qualifications here renders this unlawful.
Well, firstly, that depends...
On your logic, with all due respect,
No,
Justice Davis.
No, it's not my logic, it's the point I'm putting to you. I'm putting
Of
to
the
you
question.
I'm putting to you the point that, well, of course, not all sentences go in front of the minimum sentence, so you can't really rely on that. because-
I accept that.
Number two, the fact that you give me examples is very unhelpful. I mean, because each case depends on the facts of the case. It also depends on evaluating those facts.
Yes.
All I'm simply saying is, I mean, what you go
But
back
against
to-
what metric,
you're going
Justice
back
Davis?
to is saying the whole. I mean, in a sense, this entire case is predicated on one fundamental principle: bias. Everything flows from bias because your whole case is they're biased, they have to be constrained, therefore we've got to look for constraints. And what we're testing
Yes.
is now if you can't, the problem is if you look at, well, let's just have a look at this. If we say,
Where, are you in the Act?
now I'm looking at that, if
Yeah.
we say that 12.3 and 12.4, for example,
Yep.
for 1.12.2, 12.3, are not being constitutionally attacked, if they aren't,
No.
then that means that we must make the assumption that the House can appoint a standing committee, that it's got to deal with these particular matters,
Yes.
etc., etc.
Yes.
So the point is that what I'm troubled by is if that's the case, your inherent bias would. Why did you not attack those sections?
No, but that's a false litigation burden with respect.
Well,
we don't
with
have to.
respect,
We
the
don't have
question,
to.
No, but the question is, once you assume 3/4 of the structure are immune from constitutional attack, I'm not entirely sure you can say, well, the final leg
No.
is therefore infected.
With respect, I disagree, and the reason I disagree
You
is
have to
because that
disagree,
takes us back to the original point that we were debating in the morning about earlier this
It's still in the morning,
about are we? It feels like it's been quite a long
I
time.
know that. I appreciate the
That-
work
I'm
on
glad that
that.
Justice Davis has sympathy for me.
Enormous stuff. In fact, I'll give you a cup of tea in 5 minutes.
But I'm going to take you up on that. But that being said, firstly, it's a false litigation burden.
Okay.
These individual sections can be attacked on their own merit, and the court cannot, with all due respect, say that the attack on the individual section must fail because of a failure to attack other sections in the same
but just
sub-provision.
hear me out. What I'm trying to say is that on your logic, the earlier section, the concept of bias is, these are politicians who are going to peddle their own political agenda. Well, if they are politicians, and that's why there's bias.
It's a structural form of bias. It's
Correct.
not necessarily a
But
personal form of
if 3/4
bias.
of the structure is regarded as fine, right? What does that say?
No, but
No, it's
taking.
not fine, it's not attacked. Is
But-
that what you
but
said?
with
Well,
all-
it's got to be fine then,
No.
because it's not attacked.
No, with all due respect, both Justice Davis and Justice Fortin, the difficulty with the supposition that is put to me is that that would have the necessary consequence of robbing Parliament of performing a function that is constitutionally and politically appropriately preserved for the majority. The issue of bias here is not constructed that bias equals no majority participation. It's about if bias, as a result of majoritarianism, which is baked into our political system, is a fact we have to live with in a representative democracy of ours, it becomes how are the constraints and the checks and balances, either in the statute, constitution, or the act, collectively applied to constrain the possibility of abuse emanating from a systemic feature of the act. That's the point.
Yes, but the problem that you face is one of the reasons I suspect that you have argued as your first point, a point which was covered by Judge Lordlaw's judgment, that you need an outsourcing, is because from the beginning, from the moment this starts, the very idea that a standing committee can deal with this is flawed because of inherent bias. That's why you wanted the independent person. Now, if you lose on the independent person, right, that means inherently the court so far have suggested that bias doesn't come into that.
But I'm willing to accept that for the sake of the argument.
That was what. Surely you attacked this. In fact, I don't have to ask you. I know that you've told me.
Yes.
Right, so carry on.
So the point is it's about when that discretion-making power afforded to the committee is subject to no constraint. And what we are saying, in our constitutional system, it would be wholly inappropriate for my client to try and take away majoritarian-based decision-making and locate that determination squarely in an outside third-party source who has no democratic legitimacy and accountability at all. My clients are not here trying to say that democracy needs to be undermined through backdoor processes of independent disciplinarians. That's not what we're saying. It's only the fact finder. Because
once you abandon, once we say, because we're bound by a judgment, that the fact finder has to be Parliament itself, then essentially only your argument then must boil down to the following. Okay, the standing committee must stand as it is, but even then, when it comes to the sentencing component, the recommendations, right, when it comes not necessarily the finding of guilt,
not the conviction, but the sentencing.
So your case then reduces to, and I'm not saying it doesn't reduces means makes it less serious. Your case essentially focuses on the fact that if we've got to accept that there's a standing committee with all the inherent problems therein, you would expect this act to have given greater guidance to that committee and to the House as a whole, rather than having it in what you would regard as an unsatisfactory and unjustifiably unfettered thing. That's your submission on 12. On
6.2 of the amended notice of motion.
Okay. Yeah. All right, let's move on.
Okay. I think we
understand you, and that's all we have to do.
May I then go to 6.3 about these bundle of fair trial rights, which is about which is specifically about no discretion around the right to cross-examine witnesses, the discovery of documents and information, and the standard of proof. So the first point is that if we go back to that schedule, which starts at paginated page 80 of the record, does the court have it?
Yeah.
If the court looks through that particular schedule, which is only 3 pages long, you will see that there's not one word that is stated about the appropriate standard of proof for a charge to be proven or not proven.
Because it's not a court.
Yes, but we would say that the absence of guidelines regarding what standard of proof a subject of the schedule would have to meet is actionable in and of itself.
Well, once you've found somebody, you say they either committed, in this particular case is a good example thereof. You look at the video, you look at that, you say that breaches the rules. What standard of proof do you want?
Well,
criminal one, civil one? Surely.
Well, exactly. But that's exactly the point with respect.
The point about it is, I'll tell you what the danger of this is. The
what
danger,
the...
the danger of this is
Yes.
exactly what we saw happen in the public protector hearing. It was a disaster. It went on forever and it was total waste of taxpayers' money because frankly what was required was a recommendation to the committee. It's not a criminal or civil trial. It's a straight investigative process. Make your representations. If they're valid and they're not taken into account, you've got a review power. If not, move on. You trying to develop a full-blown... I mean, it would be almost impossible to discipline anybody going for months.
No, with the greatest
Oh,
respect,
really?
I
I
disagree
think we've
with
got
that.
precedent of that.
With the greatest respect, I disagree with that. And I think
Well, you
that
may, but the facts show differently. What I'm trying
not
to...
the facts in this case show that Parliament waited 8 months in
Yeah, but
order
they
to
did
initiate charges against my
sorry,
client.
but
That's,
with respect,
that's
there are
Parliament's fault.
There are lots of explanations for that.
Well, I'm not sure that they're necessarily
But
cogent
sorry,
ones, but I don't
I-
think it's appropriate, with all due respect, to look at what happened in respect of the public protector inquiry,
No, but the
with
problem
all
is-
its difficulties based on the contingencies of that matter,
No.
and impose that here.
Possibly, but the problem when you
Thank
give an
you.
order, the problem when you give an order, you think through the consequences of an order.
I accept that.
Right? It's very important
I accept that.
because what happens is the next case comes up, somebody like you argues exactly, look what they did here, etc. So I, speaking for myself, I want to be careful about this.
I accept that.
Right? Now, let me ask you the following. Your client would be entitled to legal representation, correct? They eschewed that, did they not? Because Mr. Malema said this was a kangaroo court.
Where the committee, if we're looking at page 80, the legal representation is a qualified, right? Because if you look at line 2, it says, where the committee is of the view that such legal representation might be essential for a fair hearing. So it's not an absolute right, it's a qualified one, and this
Okay.
speaks to this bundle
Okay.
of fair
But
trial
if they-
rights
if
which
they
we're
did
raising
not-
as an
If they
issue.
did not do that, they may have been acting unreasonably.
Yes, I accept that. They denied the legal representation on the facts of this
What
case.
is the
Fine.
difference between this and, let's say, a standard disciplinary hearing and an employment context?
In what
Well,
sense?
we don't have a trial there.
Well, it
I mean,
it
Labour
depends on the
Relations-
particular employment forum that you're dealing
No,
with.
when
If
you
internally to a
disciplined by
company
your
in front of the
employer, when
CCMA.
you're disciplined by your employer, there's an independent person. You make your representations, the employer makes these, and they make a decision.
Well, I agree. There's an independent person. There's no independent
I
person
know,
here.
no, but we've
There's
got
no
past
independent.
that. No,
there's
I
no
know,
independent
no,
decision maker
let's
here.
not go back
So
over
that
it.
example is helpful to me, with
No,
all due
it's not
respect, because it
helpful
makes
to
the
you
point.
because- No, it's not helpful. You're snatching at straws here because...
That's your
if
example, with all due
if you
respect,
make
Justice
it-
Davis.
No, you trying to say there should be a full-blown trial process. I'm saying in ordinary disciplinary hearings of any kind, it doesn't happen. Why should Parliament have to go further? We're not
Because
talking,
Parliament-
I'll tell you why. We're not talking about somebody being kicked out of Parliament forever. We're not talking about that at all. We're talking about a temporary suspension at best.
Yes, but we know that the temporary suspension can, in and of itself, be used as a weaponized form of punishment of political opponents. This is
Well,
what's
if it
foreshadowed
was-
in the
if it was,
EFF2
then I'd be-
judgment.
I'm sure that if it was, you'd be here in
Yes,
court
but we
arguing.
also know in the Glenister 2 judgment, for example, where about that.
That's
But
he has no idea. He has no idea knowing what the relevance of that is. That's all
Yes,
he's saying.
that's-
And he
that's
can't
not-
help us.
Maybe if I develop the argument, I can help everybody.
Well, okay. Well,
And I'll make
I don't
sure.
want to spend a devil amount of
No,
time
I
on
don't
this.
want to either. I just want to give some
okay.
references. And
I'll
we'll
give
give
you some
we'll give our
latitude.
we'll give our learned friend copies of these
Very
documents.
good.
It's fine.
Okay, carry on.
Thank you. What does the committee say? The Privileges Committee. The Privileges Committee says, before we embarked on the substance of the inquiry, we sought advice from our legal advisor, the Right Honourable Sir Ernest Ryder, former Senior President of Tribunals and Lord Justice of Appeal, from Speaker's Council and from the clerks of the House on how we should apply the general principles of fairness, the rules of the House, and the procedural precedents that were available to us. I'll take it nothing further other than to say that the discretion that the committee in that instance ultimately exercised was subject to the input of an independent legal advisor providing advice to that committee. We say the equivalent is what we're asking for here for a fact-finding done by an independent senior legal practitioner. That's point number one. Let's talk about the Committee on Standards, because my learned friends don't distinguish, it seems, between the different procedures in front of the Privileges Committee and in front of the Standards Committee. But what you might know about the Standards Committee in the British system is the British system externalizes entirely work that the Committee on Standards ultimately decides to an entity called the Independent Expert Panel. And the Independent Expert Panel is a body of the British Houses of Parliament established in 2020. It is entirely independent of Parliament, and none of its MPs are members of Parliament. So in other words, the Committee on Standards in the United Kingdom goes even further than what we are asking for the court to do here in these particular proceedings. And what they also have is they have the Parliamentary Commissioner of Standards. And the Parliamentary Commissioner of Standards is in charge of regulating MPs' conduct and propriety. So that demonstrates again, it's even further what they do in the United Kingdom than what we're suggesting. So our learned friend's submissions, taken up it seems, that no other parliament in the world does this, is not actually correct. Let's look at what they do in Canada, because our learned friends also rely on Canada. What does it say in Canada? Under staff assigned to the committee. In the executions of its functions, each committee is normally assisted by a committee clerk, one or more analysts, and a committee assistant. Occasional assistance is also provided by legislative clerks and lawyers from the Office of the Law Clerk and Parliamentary Counsel. These individuals are non-partisan and serve all members of the committee and representatives of all parties equally. Now, you know why we raise that is because we say that the initiator is not truly independent, because the initiator simply acts as the hand of the committee.
Could I just put this to you?
Yes.
Have you considered page 375 of the record, which is the answering affidavit, where there's quite a comprehensive couple of pages on the English system, which is part of our evidence, by the way.
I'm there.
Well, it's really interesting, because I'd like you to have a look at 1183.
Yes.
In fact, contempt for conduct in the chamber is generally dealt with by the House of Commons. The most recent example is the 2023 committee into the conduct of former Conservative Party Prime Minister Boris Johnson for lying. The UK committee is made up entirely of MPs. 4 of the 7 from the Conservative Party concluded that Mr. Johnson was guilty of lying, recommend that he be suspended for 90 days.
Yes.
Right? So, what do you say about that?
But
Is that what you...
the point is that the committee, in the discharge of its function before the report can go to the House, is fettered by virtue of the presence of independent legal advisors in determining how the committee should or shouldn't operate and giving it advice.
But
And
that may be, but since we take that out of it, at the end of the day, the committee made up of members was the committee who made the recommendation for suspension.
Yes, but
and the House. So that second part is exactly what we do.
Yes, but except the first part is not there, and that's the point that we're saying is the necessary safeguard in the system.
Okay.
Which is a fact finder.
Yes. Alternatively, the fettering
Right,
then by
okay.
virtue of the requirements and the sanction.
All right, got you.
So that was Canada. So it seems that parliaments around the world do these kinds of things. In Australia, we'll make a copy of this available, but what we will tell you is it's this. The Australian Committee ensures that natural justice is done, and among the special procedures that they have, the persons subject to the investigation are notified in advance, the specific nature of the allegations are given, and all reasonable opportunities to respond to make written submissions are given. Now,
That's pretty similar.
Sorry, my apologies. We have received none of this. I just want to place on record that we haven't received. Canadian or other authorities that may follow.
None of that was in the replying affidavit either.
It was not in the papers.
No,
We're
which is
not in
quite
favour.
interesting to me.
Yes.
How am I supposed to deal with that? I mean, bearing in mind that they put this in the answering affidavit.
well, let's look
And
at what...
they haven't dealt with it in their heads and haven't given us a copy either. So
No, that's
we are
true.
completely in the dark.
No, I'm sorry, with all due respect, that's not correct, because let's look at what they actually say in their heads of argument around foreign law, which comes after my heads of
Their
argument.
heads of
Answering
argument.
affidavit.
Their heads of
When the
argument.
answering affidavit, is there anything in the reply?
I'll ask my learned juniors
I mean,
to
plus
find the
from
reference.
Evans does have some role here.
I'll ask.
I can short-circuit it for you. I don't think there's anything.
The point is.
Well, I couldn't find it, and if I would, I'd love to see it. Well, your junior can have a look. And
Yes,
see if there's something.
I will
don't
ask
want to
them.
retain that.
I will ask them.
Let's move on from the foreign law to the other points that you wish to make. You can come back to that if you wish.
No, I think I'll finish the submission with all due respect, because I want to round it out because of the nature
we've got a
of
problem,
the goalpost
because
shifting
if
all
there's
the
nothing
time.
there, I'm not sure what we're supposed to
No,
do.
no, no. The point is that this court knows that it's entitled to take legal points, not necessarily
These aren't
raised
legal
on the
points, they're factual
papers.
points about another country.
No, no, no. But then my learned friends are not entitled to simply say in their heads of argument, which comes after my client's heads of argument, that these are the appropriate comparators,
But could
comparators,
you,
and
with
when
respect, they raise those points, surely it behoves you, either in the replying affidavit or your heads, to deal with it. You haven't. I mean, I'm put in a very difficult position here of not being able to debate this with you because I've got no idea about what you're saying until I've read them stuff.
So
Sorry.
may I try and be of assistance to the court? If the court can look at page 919,
Yeah.
paragraph 148. That's the reply to our paragraph 118.
Well, that's my difficulty. Anyway, all right. Look, to be perfectly frank, I don't think this is going to be the critical point in the case, so that's why I suggest you move on.
I'm indebted. The point being that other parliaments in the world
I'm
do
trying
seem
to
to
guide
do
you in your argument. I'm just simply saying.
the point being that parliaments in other parts of the world seem to
May-
do the
okay,
kinds of
so
things
let's-
that we
let's
are
leave- let's
suggesting
leave it
is
as
part
such.
of the minimum core protections for opposition MPs in the
Yes,
position of my clients.
I read it. Let's leave it as
I'm
such,
indebted. Thank you. I'll move on.
and let's move on to your
Oh,
other submission.
before we move on, may I hand up the two
Yes.
additional bundles
Yes.
of authorities that didn't get handed up this morning?
Yeah.
Thank you.
I'm reminded, actually, that once when I sat in the Composition Appeal Court, and counsel only brought one set of heads. Justice Selekovitz said he wasn't presiding. Does that mean I've got to sit on Justice Davis's lap to read the head, to read the authority? Have everybody got them now? That's wonderful. Okay, Ms. Miller. So let's move on beyond the foreign law to
Yes.
where you're going to take your argument. Please feel free.
Thank you. I'm indebted. So we were debating then the 6.3, because remember this
Yes.
emerged in terms of the
Yes.
fair trial rights,
Yes.
the bundle of fair trial rights,
Yes.
and that's why I started with making the comparison about employers' rights and checks and
No, I
balances and all
understand
those
what you're
kinds of
saying. Yes.
things. Yes,
And
thank
we-
you.
yes.
I'm indebted. What you will also know,
And the
even-
point there, if I can just, you can put it for my benefit, not yours, is that I should not, since I raised it, take the concept of the labour
yes,
case as essentially a form of saying, aha, that's the answer.
Yes.
Because on your submissions there are significant differences.
yes, that's right.
For all the reasons that you've advanced.
Correct. That's right.
fine. Move
That's
on.
right.
Yeah.
Can I just say then, in the context of 6.3, because I want to just specify. You had the debate about standard of proof. There is actually in the New Zealand Parliament where they specified was adopted as a specific standard, but I'm not going to take it there. That's the issue on this. That's the issue on the standard of proof.
Yeah, great.
What you will know about the issue about the discovery of documents and information, and even though this is a review ground, I'm foreshadowing it now, because it's about the equity of arms between the powers afforded to the committee as both the decision maker, the ultimate decision maker, but also then the decision maker in the round of the hearing, who then gets to adjudicate requests and whatever from my clients or people in the position of my clients versus the initiator, and the initiator is essentially the hand of the committee. So the point is that the system creates the system is flawed in that there is insufficient independence, firstly from the initiator performing the function of pro forma prosecutor, but alternatively, if that is deemed to be acceptable, then there's insufficient safeguards in enumerating the equivalent rights of my clients to be able to prosecute or subpoena or whatever other of the fair trial rights are that we rely on, because as you know, that is ultimately subject to the discretion of the committee, but it results in the committee being, in effect, conflicted in the judgment that it has to reach of its own hearing and the procedural fairness thereof for the conclusion that it wants to reach.
Can I ask you just one final question on that? I think, personally, I understand submission fully. Does it make any difference, the factual context? In other words, in this particular case, it appears to me the evidence was a video. In fact, the evidence was that the whole country saw what happened. And there was a video which occurred of your clients alighting, if I could use a neutral word, the stage at a particular point. I mean, what discovery is he required? The only material evidence was the video.
No, yes, but you'll remember on the specific subject of the video, there was a dispute as to whether or not the video that was given was the one that correctly recorded all of the events that were relied upon for the purposes of disciplining my client. And then there was a dispute as to whether the video was sufficient or not sufficient, and ultimately the committee gets to decide. And remember, the committee gets to decide not sitting as an independent, neutral arbiter. It does so where it itself, under the hand of the initiator, is prosecuting the very people that it sits in judgment of. And that's the systemic flaw that we say is the problem.
But what discovery would have been required? In other words, what other documents would be required in this case? It would have just been the video.
Well, yes, but that is not an answer to the principal point that we're making, which is about the equity of arms.
But the whole case was one, did they alight the stage? Does that constitute a breach? And three, does it constitute a serious complaint? That was basically what the entire case was about.
Yes.
That's common cause, isn't it?
I mean, no one denies it.
I'm hesitant to say yes, it is common cause, because I don't know what I'm necessarily conceding.
Well, what is Mr.
So I apologize, Justice Fortin.
Yes,
But isn't there some extent in which that was agreed? That is what happened.
Yeah, lighting the stage as.
Oh, you mean in terms of the
actual factual happening?
but that's no answer. That's no
No,
answer to
that
the
was the only
principal point.
question
Yes.
I'm
Oh,
asking.
then I concede. I concede to
That's
Justice
all I'm asking.
Fortin's
Yeah,
submission
So
summary
all
of
I
the
was-
facts,
so all
but
I
I'm
was
resisting the supposition from Justice Davis. I think
all I
about.
was asking then, sorry, all I was asking on that particular basis, what? Well, I suppose I'm trying to probe two things. One is, assuming in this case that all that was required was the video and that there was common cause in relation to that. Does that give you justification for relief in this case, or is this a principle?
Second leg. Okay. Because remember, the evidence and the content of the evidence in the video could have had the effect of allowing my client to raise certain defenses which they couldn't raise, potentially, in the context of the hearing. But we would never know that because the video was withheld. And the reason the video was withheld is because the system creates an inequality of arms between the committee, who has the initiator running the proceedings on their behalf, and who they sit in judgment of ultimately, versus my clients who most of the time only get protections when the committee agrees that they deserve those protections.
All right, got you. Carry on.
Can I just give you a reference, because we were, my learned junior did find what you're asking for. My learned friend addressed you at page 914, I think. Let's look at page 890 together and 891.
Is that the foreign? Are we back?
Yes,
Back
it's
on.
just where it's dealt with Foursquare.
Yeah.
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 Paragraph 69.
What's the page?
890 to 891. And I think actually maybe it's helpful for me to read this. Sorry. Also in 886 and 887.
Is it your reply?
Reply. So 886, para 52. The example from the UK was offered to illustrate how parliaments have responded to crises of legitimacy within their committees. And then it goes on to deal with that. In the next paragraph on 886, para 53, other examples will be more fully dealt with in legal argument, but some innovations in Australia, where the Senate Standing Committee is not composed of proportional representation, required to be nominated by an opposition MP in the Senate. And then it talks about New Zealand. At page 890 again, paragraph 69, it talks about New Zealand and Australia. And then over the page, it talks about and this is the conclusion, and this is the point that we're making, which is why their resistance to this is unfortunate, those standards clearly set on their publicly accessible information pages. In other words, you know what it is, fully enumerated, the procedure you have to come and meet.
That's a comprehensive answer to reply I'm not going to get into now.
Thank you. I'll move on then.
I'm not sure it is, but that's another matter. Carry
Indeed, that's for you to decide. But anyway, we were talking about the...
We had reached the point where we had spoken about the discovery,
Yes.
etc.,
Yeah.
and we can move on.
And I think there was
got
the
the
second part of your summary
You're-
that
you're- sorry
that
to
I
interrupt-
accepted
sorry
as
to
being
interrupt you, but
correct.
I mean, effectively what we're submitting to us is doesn't really matter the specifics of this
That's the
case.
principle
Yeah,
of it.
It's the broader principle that you're on.
This is the constitutional relief,
Got it?
absolutely.
Move on.
Can I just say briefly then, in respect of 6.4 of the amended notice of motion, the issue about they failed to provide a time bar for the institution of charges against an MP. The principal point here, and this is the debate we were having earlier, Justice Davis, about the effect of the suspension, is that given that the initiation of the charges and the prosecution of the charges rest in the hands of the majority, we know what EFF2 says about that, the fact that there is no time bar means that that is open to abuse. And that really is the point. Because as I was saying when we were debating this point earlier, in the hands of a majority that has a perverse incentive structurally to inflict political pain on its opponents, the time bar of the issue here is that you might be suspended 8 months later during the budget vote, or you might be suspended 8 months later when there's a motion of no confidence, or I might be suspended where there's an impeachment inquiry. So the principal point is that in the absence of a time bar to ensure that cases are timeously instituted and prosecuted, it's the weaponization of an otherwise neutral disciplinary process that
Again,
creates
the principal issue. Again,
Yes,
this-
yeah,
the
complete.
principal issue. You want to bring it to the facts?
Completely. I'm going to
No,
deal
no,
with
later,
it. I'll deal with that a
later.
bit later. That's the review relief.
All right, okay.
Yes?
I'm indebted.
Okay.
I'm indebted. May I just take an instruction?
Yes, you might.
Okay. Thank you. I'm indebted. Just then to just highlight in respect of 7 and how one reads 7.
Are you still maintaining that it links to 6.1?
You got me then. But it's not even 6.1, it's a bit more than that. It's about 6 in the introductory portion.
Take us through 7.
If you, so 7 says declaring the impugned rules relating to the powers and privileges to the extent that they fail to meet the requirements set out in section 12.3a. The 12.3a, if the court still has the act
Yeah.
in front of the court,
Yeah.
on internal page
Yes.
6 at the bottom,
Yeah.
it says that the inquire into the matter in accordance with a procedure that is reasonable, that's step 1, and procedurally fair, and then table the report. So how you read 7 and 6 is that the impugned rule, which is 214, identified in 6, falls short of that standard for all the
reasons
enumerated.
that you really advanced.
Exactly.
Absolutely.
That's it.
Move on.
Thank
We've got you.
Thank you. And then let's look at...
And 8, I think, we've already debated.
I think we foreshadowed that.
Yes, you have,
Is it generous? Is it
Yeah.
ungenerous of me to say that, or not?
No. All we need to know is what your submission is, and to understand it, we do, you can move on.
Yes. And you've got it because of the imposition of sanctions
absolutely.
point,
Yeah.
and we've debated that
Yeah,
already,
yeah,
and we've read 12.5 and 12.9.
Absolutely. Right.
Okay, now let's go to paragraph 9, which is the review relief. But before I delve into each of these individual things in para 9, can I just go to para 10? Because effectively what 9 does is 9 says declaring as unlawful and invalid, and 10 then mirrors that by saying essentially in the alternative review and set aside.
Yeah.
So I'm going to prosecute the same arguments, but hopefully they land under one or both heads.
You carry on.
Thank you. And then, of course, prayer 11 is just the timing of the order, if you're with me. which I'm not going to spend too much time on, and costs I can say something about a little bit later
Right at
if
the
I have
end,
to.
but basically it's 9 that we want to hear you on.
Yes, exactly.
Keep going.
Thank you. So let's go to the review relief, if I may. If the court will bear with me, I just need to look through my notes, which have long since been abandoned whilst I've been debating with the court.
That's why you're here. So we'll wait patiently.
I'm indebted. Okay. So, under the review relief, the first bundle of decisions, if we keep 9.1 open in the amended notice of motion, are what I'm going to refer to as the committee's decisions. And those were the committee's decisions in the context of the proceedings. And I'm going to demonstrate how those decisions amounted to reviewable irregularities. 9.2 is pretty straightforward, which is the adoption of the report, including the sanction. And 9.3 is pretty straightforward as well, because that's really the
Would I be right?
poison
saying
fruit,
that-
if it were.
Sorry to interrupt, but
No
9.2
problem.
and 9.3 really have, if we accept your earlier submissions, they must follow.
Wait, which earlier submissions
Well,
is
the
the first
submissions in
question?
relation to the penalty,
Yes?
sorry, well, hang on, let me get this right.
Yes, please.
Is the
That will help
penalty,
me.
is the argument with regard to the penalty that there were no guidelines?
Yes.
Or,
Yes.
or would you say, in any event, this wasn't a serious complaint? If I could just pigeonhole the 9.2 point. What, in other words, if I was writing the judgment in your favour, what would you want me to say which would sound plausible?
Okay, can we delineate it as follows?
Would you
Can
like to do that later? I'm
No,
just
no,
saying
I'll do
I've
it right
taken you
now.
out of, no, I've taken you out of sequence.
No,
So
no.
I apologise for
May
that.
I, there's no problem at all, Justice
Yeah,
Davis. I'm
yeah.
indebted. It actually
Yeah,
helps
okay.
me as well. Can we
Okay.
look at paragraph 9.2 together,
Yes.
please, if
Yes.
we
Yes.
can? In line 2 of 9.2, it says conveying its guilty finding. Can I ask you to draw a line or make a mark after the word finding? Okay? Because what that really talks about is that is related to the conviction, which flows from the decisions taken in the proceedings, and that's the link to 9.1.
Okay.
Yeah.
So
Okay.
that's the first part of the answer.
Yeah.
The second part of the answer is that in respect of the recommendation of the penalty and so on, Justice Davis, yes, I'm happy to accept that my sanctions penalty arguments would apply as against that.
Yes.
So insofar as the second portion of paragraph 9.2, I foreshadowed some of those arguments. And what I ultimately say is that the report then could then be scuppered on one of two bases, either the conviction part, in other words, everything before the word finding, or on the sentencing part, everything thereafter.
Right. So the first part of 9.2 is coupled at the top to 9.1.
Yes.
And the second part is coupled to the fact
Yes.
of the submissions that you've already made.
Yes,
Yes.
that's right.
Okay.
And then,
I understand where you go.
yes, and then remember also as well, because the report only becomes, I think I want to use the word implementable, it's not the right word. It only is adopted and therefore becomes an effective report in terms of imposing the sanction when it serves in front of the National Assembly.
Yes.
And obviously, what I would say, and maybe I shouldn't say obviously, is that what we would say is that the poison fruit doctrine would apply, that if we can vitiate either the proceedings before the committee or its adoption of the report, the consequence necessarily follows as regards the National Assembly's
I have
adoption.
you.
Then I think we're okay.
Okay, so
on
let's
this
go.
point
So
now.
we can revert back to 9.1.
Yes,
I'm
let's.
sorry for.
No. I think
Okay. No. All right.
I thought that was very helpful.
Okay,
Thank you
okay.
very much, Justice Davis. So, let's go to the refusal to provide So one of those decisions is the Speaker's refusal to grant the applicants the access to the full video footage of the events of the SONA. That does relate to the principal point that I was making, because remember, both the Speaker and the committee reached a decision that it was irrelevant. But the point that I'm making to you is that their opinion as to the relevance or otherwise is not the critical test. The critical test is whether or not the video exists, and if it has an impact on the legality of the outcome of the hearing and the finding against me, my clients should ipso facto be entitled to that, because that's about an access to evidence issue. And that and this relates to the principal point I made earlier, because in the absence of appropriate guidelines as to how the committee exercises its discretion in respect of these kinds of interlocutory disputes, I suppose you'd call it, is the problem. Because the committee can effectively convict my clients on indirect or weak evidence or incomplete evidence. And that's obviously a reviewable error. No. I'm
asking.
I'm cannibalizing the principal submission I made earlier, and I'm saying it applies foursquare then as that decision in the context of the review head of relief.
Yeah.
Thank you, Justice Forte. The second decision that we can zone in on is we can zone in on the refusal to grant the postponement.
Yeah.
Now, the refusal to grant the postponement is important for two reasons. Firstly, remember at the time that these hearings were happening in Parliament, there was other litigation launched by other EFF MPs around whether or not there is an equivalent subpoena power for a charged MP to subpoena a witness to the hearing to give evidence, and that was in front of this court. So one of the reasons for the postponement was the one that you would expect, is postpone to see the outcome of that, and then let's see what the outcome is and whether or not that has any influence on us. The fact that the committee persisted notwithstanding, we would submit, is a breach of my client's rights.
But isn't it their discretion to grant or to...
Indeed, but we would say it was an I'm using the word of judicial officers applying their minds to discretion. I'm going to use it all the same. I would say it's an injudicious application of the discretion, because it's as though we are here in this court arguing about these facts. Let's say by some miracle the blue party, and I'm not suggesting any particular party, I'm calling it the blue party.
Perhaps we should call it the pink. No, that's not the pink party. I'm trying to think of a neutral term. Carry on here.
The beige party. That might be the blue party.
Okay, I think that's fine. Beige party. Okay, we'll buy that.
But you know my example.
Yes,
you
exactly.
know what I'm suggesting.
Yes,
Let's say the beige blue party, combination of the two colors, ended up in the Constitutional Court litigating similar facts. Maybe not even the Constitutional Court. It could be an interdict hearing in front of a single judge in this division, or in another division of the country. We say it's an injudicious application of the mind because that's a relevant and material factor which would have clarified how the proceedings here against my client, our proceedings here today, could or couldn't be resolved. So in as much as, yes, it's a discretionary power afforded to the committee, we would say that they are constrained by exercising what I'm calling a judicious application of the discretion, which they failed to do on the facts in respect of my client. I don't know, Justice Nzibeni, if it's an answer. I don't know if it's a helpful answer or otherwise. The second related reason then in the context of the postponement is, remember that there's a dispute that arises in front of the committee vis-a-vis the evidence it is relying on in order to convict my clients. So if I'm not mistaken, there were 6 witnesses, 5 of whom were technical evidence, that one witness who gave oral evidence. Sorry, I'm confusing the matters. In the other Menti Maria matter, there were 6, but in this one, there was 1. So,
is this your
yes,
people
Mr.
advocate?
Clauser.
Is this your people advocate who seems to know what's going on? Which is,
at least someone knows
fills me with hope for the future.
Absolutely. No, Ms. Naidu portends well for the future, my lord.
Yeah, it was only Mr. Clauser.
Yes, that's right. But that's
he was the only.
Yes,
Clauser was the only.
Yes,
witness.
correct. Because something similar happened in the other proceedings. But Mr. Clauser is who Mr. Clauser is, and he gives the evidence. Now, in respect of that, there are 2 issues which we say, maybe even 3 issues we say, arise as a consequence of that. The first one is, remember, when my clients, I think someone said earlier, alighted the stage to give the president a cup of tea because he was thirsty, the speaker was in the chair at the time.
Yes.
When the speaker exercises her powers in terms of the rules of parliament, she has to follow a particular procedure in order to do so. Okay? I hesitate to ask the court to go there because I don't think that the full set of the rules of parliament are in the bundle. But you can take my word for it at the moment, and I'll make sure that a full copy of the
what is the
ninth
point you're
edition,
trying to make?
the ninth edition is with you, is that in terms of the escalating powers afforded to the Speaker before she triggers the ejectment power, which is housed in Rule 73, there is an internal process, splitting the difference, by the way, Justice Davis, between something like disorder and grave disorder, undefined. But let's accept that for what it is. You know what I have to say about definitions. The Speaker has to go through that particular process in order for her to satisfy herself. Now, when it comes to the hearing, remember the consequence of the Speaker's ejectment decision is what it is. But in front of the committee, my clients should have an ability to cross-examine the Speaker about the assessment she made in terms of those rules, because if the Speaker, and I'm sorry that I don't have it in front of you, but you only get ejected from the House in terms of Rule 73 when it's grave disorder. And the stagger in terms of which the Speaker has to go through before she can reach that is something that she must assess. Now, if, for example, at the hearing of the committee, my clients were able to cross-examine the Speaker, and remember, they weren't able to cross-examine the Speaker because they were prevented from doing so. If they were able to cross-examine the Speaker, they might have been able to establish through cross-examination that the Speaker actually didn't apply her mind as she ought to have done in the context of purporting to exercise the powers in terms of Rule 70, 71, and 73. Why is that relevant? And it's something that Justice Davis foreshadowed with me. Because in the context of extracting those concessions from the Speaker, maybe the committee would have taken a different view as to the conviction. They would have said, you know what, maybe the Speaker overreacted. Or maybe she, I don't know, she misapplied her mind, and the consequence of that is we're not going to find it.
Why did that need cross-examination? Why could they not have put that up as representation?
Well, they didn't, firstly.
Well, that goes back to the whole postponement problem.
Yes, and then also remember the further problem from that is the witness they rely on is Mr. Kaso. Mr. Kaso is not the repository of the power. So in circumstances where my clients ultimately are going to be convicted of contempt of Parliament, which stems from what happens in terms of the Speaker's powers of Rule 70, 71 and 73, the absence of the Speaker and the inability to cross-examine her is the reviewable breach.
The argument I suspect the other side will put up is this, which is that what the offence was getting onto the stage without permission, disrupting the process in circumstances where at least there was a perception that they were threatening the president.
Fair enough, but the point is,
and you don't need more than that.
No. But the point is, with all due respect, you can't go to say you don't need the Speaker. The Speaker is the repository of the power.
Sorry, but how?
That's as good as, with all due respect.
Sorry, but assuming the Speaker had acted improperly, how
Yes.
does that help you? What is that? It can only be in mitigation of sentence. It can't possibly be.
Even if it's at that lowest level of mitigation of sentence.
No, because the conviction was based on.
No.
I mean, it must follow.
No.
You surely can't argue that it would be unreasonable to convict somebody for actually charging up onto Parliament, onto the stage.
No. Let's take several steps back with respect.
Well, that's the only issue that's before us.
No. Let's take several steps back.
Yeah.
In the context of the committee hearing, where the ultimate decision reached by the committee is a finding of contempt, that finding of contempt doesn't float about in the air on its own. It's related inherently to the underlying facts which gave rise to the charge of contempt. The underlying facts which gave rise to the charge of contempt, yes, factually, is my client's alighting the stage. But you only trigger the process to reach a finding of contempt based on the Speaker's application of her power.
I'm finding that very difficult to understand.
It's actually quite simple,
I can't,
with
yes,
all due respect.
On some broad causation points, but the simple
No, it's
problem...
not a broad causation point.
Well, it is, because...
No, it's not, with due respect.
Your clients were convicted because they alighted the stage where they were not allowed to, and they disrupted the proceedings which they're not entitled to.
No. So this
There's
is
no
the point.
defence to say, well, the Speaker should have given them further warning.
But this is the point. This is the point. If you're going to convict my clients of contempt, which is a very serious offence as we were debating in the morning, you get there by the Speaker exercising her powers in the context of the rules. Absent the Speaker coming herself and saying, I was of the opinion that this was grave disorder, and therefore amounted to something that could trigger the remedy in Rule 73, which results in the ejectment and then the charge of contempt, you're convicting my clients on indirect evidence from an advisor who is Mr. Castle.
No, you're not. You're convicting your client. It's extraordinary to argue that, oh well, the speaker might have made a mistake and somehow that's got to do with the conviction.
Well, it
charge,
could.
What was the charge?
No, it could.
The charge how could it possibly be?
Well, because the
can I
committee
ask you
might have
this? Are
said.
you seriously
The committee might have said.
Well, let's stand back a minute. Are you seriously advancing the proposition that there can be some basis by which it would be justified to get onto the stage?
No, I don't have to justify that at all.
But that's the charge.
No, but the charge is not a free-floating charge. The Privileges Committee doesn't meru motu on the facts of this case charge my clients for contempt. That is the facts. We only get into that particular scenario after the Speaker exercises her power.
Are you saying, Counsel, that the charge triggers the list of witnesses?
Correct, because, well, yes and no. So yes, in the sense that you get into the territory of contempt. Be brought, because really what she's doing in the contempt hearing is she's justifying her decision, and she's justifying whether or not the threshold of contempt has been reached, because that's the evaluation the committee is being asked to do. So that's yes. The no part is that the committee on the facts of this case.
Is there not an assumption that there was, because the committee was set up? Don't you need her to make the finding for the process to start?
Exactly.
So you are disputing the setup of the whole process.
No. I'm saying that if her decision was a necessary decision to trigger the process, then in the context of the finding of contempt that the court ultimately reaches, the committee ultimately reaches.
Where is the charge again? Where can you find the charge?
Let's find it.
Well, I think this is absolutely fascinating. All of a sudden, this is to do with the speaker. The
Page
charge is what? Page?
87, volume 1,
Yes, that's the first
called
one.
Annexure A,
Volume 1.
1,
Page
87. Is it 83? It starts at 83.
Well, there you are. And if you look at what the charge is, look at charge 1. I mean, this is,
What page are you at, my lord?
what's it, 88, I think.
Yes.
Well, you tell me what the charge is. Because let's not be in a make-believe world. Let's be in a real world. What is the charge? We need to read this together because we can. And I will. So that if you go onto page 88, go down 3, 4, 5, 6 lines, you deliberately created and took part in a serious disturbance, disorder, and disruption, acting in a way of seriously detrimental dignity, decorum, and orderly procedure by acting together with, and the whole bunch, you ascended onto the stage without the authority to do so, threatening manner approached the president, and had to physically removed, resulting in suspension. That's the charge. The charge is that you went onto the stage and you did the following.
Yes, but I think I answered this point already in respect of what Justice Ntsiveni had asked me, and also foreshadowed by Justice Fortain regarding what is the underlying decision that triggers this entire process.
I'm sorry,
there's no meru motu charge
that is
here.
utterly irrelevant. What is relevant is what is the charge. I mean, you know, if you charge with murder, I'm not really interested in, I may well be interested in your background, but that would be for mitigation of sentence. What I wouldn't be interested in, the charge is murder. The charge here is you alighted the stage, you threatened. That's the charge.
Yes, but this is...
You can't deny that, isn't it? Everybody knew what the charge was. There's no charge that...
I've already made my submissions on
I
this
know,
point.
and I've made my point. So
Yes,
carry
I
on.
think you have.
Okay, yeah.
Anyway, as I was saying, in the context of...
But I want to go back, if I may, to the
yes,
question of the
by all
procedure.
means.
Yeah, I just want to ask you this. When it comes to the question, we were talking about the postponement. I don't quite know how we got to this particular point, but on the
I'm not sure
postponement
either.
point, where you raised the point, which is an important one, about...
Whilst you're looking for that, can I respond to something you just said to me a
Yes,
short while ago,
yes, of
Justice
course you
Davis?
can.
You said that the background might be relevant in the context of mitigation.
Maybe.
So at least we can agree on that part, that
Well,
the absence
I'm
of the
saying
speaker...
I have to consider... for speaking for
May I
myself, I have to
finish, may I
consider.
finish the point, please?
Okay.
Because I'm responding to the question that was asked of me.
The absence
or
of the
point.
speaker, you were
The
saying?
absence of the speaker, at the very least, adopting what Justice Davis has said to me, and the evidence regarding the background to the decision taken by the speaker could have amounted to a mitigatory
Could I ask
factor.
you the following? It's
Justice Davis,
Yeah.
if I'm
All right, carry on,
pleading
carry
with
on.
you to let me finish, please.
I
Because
understand your- I understand
it's
your
difficult, with all due respect, to have to try and engage one justice, and then when
All
you're
right,
giving
you-
one answer, you're
no
then having
point
to
you
debate other
protest, you carry
justices
on.
as well. So let me finish, if you don't mind. The point is adopting Justice Davis's logic in the question or the scenario that he posed to me, what we can at least agree then as a minimum threshold, at least on the question of mitigation, is the absence of the relevant background evidence as to how the contempt conclusion was ultimately reached could have been a mitigating factor. On the common cause facts in front of this court, the speaker wasn't called, and the ability to rely on any concession that might have been drawn or any issue that could have been put to the speaker favorably for my client was not in front of the committee when it adopted the sanction that it did. That's the point. Insofar as, obviously there's another debate that we need to have about the sanction and whether or not the preclusion of the submissions was correct, but I'm saying that the same logic applies then in respect of the ultimate charge of conviction, the ultimate conviction of contempt. Because all I'm saying is that if we can accept that the background information, the evidence from the speaker may influence mitigation, it could have also influenced the committee's conclusion on contempt. Never mind the actual underlying facts on the alighting of the stage. You can't look at that in isolation to how this matter got in front of the committee. Because you could do that if the committee meru motu charged my clients. But the committee didn't meru motu charge my clients. This comes from a ruling of the speaker on the floor of the House after you go through the referral processes to get from the speaker to the Privileges Committee. That's as high as the submission goes.
Well, let me put the following. You see, the difficulty I have is you running away from facts, which isn't helpful advocacy in the slightest. The charge is clear. We've read the charge. We know what the charge is. The question was whether your clients were guilty of that charge or not. Background circumstances absolutely nothing to do with it. It can't possibly be suggested that because the speaker should have perhaps given another warning, somehow along the line, that actually deals with anything to do with getting onto the stage legally or illegally.
No, but we're debating apples and oranges.
No,
with respect.
we're not. You are. The problem is
no.
I'm trying to keep to the facts.
No.
Which you're running away from.
No, I'm not
I want
running
to
away
ask
from
you the
anything
following.
with the
I want to
greatest of
ask you the
respect.
following. No. Let me put the following to you. Whether in fact...
Which facts are you relying on, Justice
Well, I'm
Davis?
relying
Could
on
you
the
maybe
charge sheet.
point me to something?
I'm relying on the charge sheet
Okay,
that you're
I'm with
desperate
you.
to run away from. The charge sheet is clear. You should know it as well as I do. And if you know the charge sheet, that's the charge. The alighting on the stage, the threatening of the president, etc., etc. There's no other charge. Nothing. You can read that as many times as you like, but it's not going to change. So the question I have for you is it's possible that there could be mitigation, but even then, I'm not sure that can be correct. I'm not entirely sure what the mitigation is. But perhaps we have to consider that. But let me move on, because you were talking about the postponement, and I wanted to ask you something about that, because otherwise we're going to forget it. Could I ask you whether you wouldn't mind turning to page 401 of the answering affidavit?
Is that volume 2?
I believe so.
Thank you. I'm indebted.
No, volume 1. I'm awfully sorry.
401. Yes, I'm there.
So towards paragraph 192, this is your opponents addressing the question of postponement. And we can move on, because I just wanted to give you an opportunity so I know what your argument is in this.
Yes, please.
The last 3 lines. The issue, therefore, is not whether this court would have granted the postponement if it had been in the committee's position. The only issue for this court is whether the refusal rendered the proceedings unreasonable and procedurally unfair.
What paragraph, my lord?
I'm sorry, page 401, para 192.
Yes, I'm with you.
Right now, 193. The applicants never made that allegation. They alleged that the request was reasonable and fair. They claim there was no basis at all to refuse it, and they claim that refusal on its own is reviewable and is a standalone basis to set aside the process. But they do not allege that without the postponement, the proceedings were not reasonable and procedurally fair. Even if all the applicants' allegations are true, and they're not, it would not be a basis to set aside the decision. That should be the end of this review ground. Even if this court is willing to read in that allegation, it was not unfair to require them to proceed with the hearing. And then they say, the applicant has not explained why it should have been granted. It's impossible to know which of the reasons they initially advanced they believe compelled the committee to grant postponement, duty on them to explain to the court, etc., etc. Can I just get your response to that?
What is the question?
Well, the question is, this is a justification that they put up for why a postponement wasn't to be granted.
Yes, and I think that my answer is self-evident. My answer is self-evident because of all the breaches in terms of the proceedings as they continue to unfold in respect of my client's ability to have a fair trial in front of the committee.
Sorry, when they asked for postponement, they're asking, what did you put before the committee for the...
Page 168, FA 14.
168.
FA 14.
Let me just have a look. No, that's what I want your response on, just that. That's the argument.
Okay, well then look at the contents page. There are the grounds.
Yeah. Is this Mr. Capido here? So he's affidavit. That one? Mr. Capido, I believe is his name.
Miss Cupido.
Oh, Miss Capido, say so.
168. FA 14.
168 is FA 14.
Yes, thank you, my lady.
Yeah? So,
So you're saying this is, I need to read this to get as the, basically this is your case. This was the case.
This was in front of the committee, yes.
yeah.
Okay.
The basis for the
And you
postponement.
say these are the reasons
Yes.
why a postponement should have been granted. Okay, got you. That's fine.
Okay.
No, I wanted to make sure that when I read the two together, I can understand their
Okay.
argument and yours.
May I just, perhaps it would be helpful to give the court the reference to where the FA 14 is discussed
Yes.
in the main affidavit,
Yes,
because
of
then
course.
that adds then the further contextualization
Yeah.
of the review ground. If I could find it in my own papers, that would be, there we go. It concludes at page 32, paragraph 56.2, but the whole analysis about the postponement starts with page 31,
Paragraph.
54. I don't think there's, I don't know if there's any need to read it out. I'm just pointing it out to you.
Sorry, my only purpose
Yes.
here was to counterpose the 2 points so that
Yes.
one can read them again.
Yes.
With the thing. And standard
Yes.
that one of the issues which was clearly unreasonable
Yes.
by any reasonable decision maker was the failure to grant the postponement,
Yes.
which they seem to have followed upon the advice of Mr. Katz, SC.
Pardon?
They seem to have followed that on the advice of Mr. Katz.
Yes. But Mr. Katz is not here, so I'm not going to talk
No.
about the quality of that advice or otherwise.
You're very welcome to if
No,
you
no,
wish
no.
to.
No, he has
No,
filed
but
an affidavit.
all I'm
doesn't he?
simply saying
Yeah,
is
indeed,
they
yes.
followed that,
Yes, yes,
and that was it.
yes.
Okay, got you. Got
Yes.
your submission. So let's move on.
Thank you. Could I just point out that FA 14 is spoken of, as I said, on page 32, but the analysis and the consequences which flow from that continues then thereafter from paragraph 57 onwards at that page, and it carries on from there.
Thank you.
Thank you.
So that takes care of the postponement problem.
Yes. And you've got my I know we disagree about this point, but you've got my submissions about the materiality of the speaker. I would say that the arguments about the materiality of the speaker as a witness to come and give evidence was also necessary for the president. Because if we go back to the charge sheet, which I think it's perhaps important to do so, because Justice Davis invited me to reread it as much
Yeah.
as I want to, so let's do it together.
What was he supposed to come and say?
Well, let's look at what the charge is. The charge is this. Without the authority, that's what Justice Davis referenced, to do so and advance towards the President of the Republic and the presiding officer in a threatening manner. So
He wasn't threatened. He didn't
Well, we
threaten.
don't know. I think is it on affidavit that the president laughed or something like that. And I'm not sure if we dealt with it. I'm going to look for that reference and
No,
come
there
back.
Mr.
is.
Paso. Is
there
Mr.
is.
Paso speaking?
No, but this is the point, my lady, is that Mr. Kaso is not the president. Mr. Kaso is not the presiding officer. Mr. Kaso may look at these factual occurrences happening and say, oh, I think it's threatening.
Yeah,
Oh, it was very threatening.
This
but
is a
he's
different.
not
I'm not saying this is an irrelevant point. This is
Yeah.
but a different point. The point you now make, which fair enough, I understand,
Yes.
is that this is not about what the speaker's rulings are. It's the question of whether the speaker and or the president felt threatened.
On this leg of it,
Yes.
yes.
Well, that's
I
exactly
was-
what you're reading.
yes.
No, I'm sticking to that. Can I just say, in relation to whether you and I have a dispute, you've been an advocate for long enough to know council puts difficulties.
Yes.
That doesn't mean we've made a decision. One has to consider your
No, no.
submissions. I just want to make that absolutely clear,
No.
since this is being recorded, that the public should know we aren't making a decision.
No, Justice Davis,
We're just having engagement.
No, I
However
agree.
robust that may be.
I appreciate that, and I must say it's enjoyable to have such robust engagement
Well,
in the
that's
High
fine.
Court.
I'm very happy that you are.
Yes.
You can buy me a cup of
Of
tea.
course,
at the
there's a
end.
certain inequity of arms given where I stand and where you
You're
sit.
doing
But
very-
be that as it may, if
You
you
are
can
doing-
invite
you're
me as a
doing very
guest
well,
on your
don't worry
television
about
show,
that.
we can
Okay,
play
so
on
now
the same
we've
playing
got,
field.
so we've got that.
He's still in charge there.
Yes,
We've got,
yeah.
we've got the postponement, we've
The
got the
BCC
question
might
that
say
your
something.
submission now, that they should have called the president and or probably president and the speaker,
Yeah.
should at least, at the very least, have been called
Yeah.
to explain why they were threatened,
Yeah.
or whether actually, to be perfectly frank, they thought this was a storm in a teacup.
Yes, exactly.
Okay.
And those are the arguments on the threatening part. You've already got my
Got-
arguments on the
yeah.
first part about
Yeah.
the speaker exercise. So then let's just look at the next one about the committee's file written submissions in respect of the sanction.
Yeah.
Can I ask the court to please go back to that code, not the code, the schedule that we were talking about and debating earlier? I think it's at page 7. The relevant one that I want is the para 9, which is at page 82 again.
Is that the penalty one?
Yes, correct.
We're on 82 again, yes?
82, page 82, volume 1. The point we make here is this, is that when the committee reaches its conclusion on the conviction, or but I'm saying it reaches its conclusion on the conviction. Obviously, it's a recommendation of the conviction which has to be endorsed by the House. But I think we're all on the same page, 82. The point is this, is that the penalty portion of that proceeding stands on a separate footing. And that's quite clear from the wording
Yes,
of,
because
of it.
must be given an opportunity.
So you know what must means in public law, peremptory, can't deviate, and the attempt by our learned friends' clients to suggest that there was some or other waiver or abandonment of the hearing is contradicted by 2 references on the facts. The first one is, and I'm looking at my learned attorney because she mentioned it to me this morning, so it's both Ms. Naidu and Ms. Cupido who are coming to my rescue. But on the facts of the case, what we know is that even though they left before after the postponement was refused, my clients, even though they left, they were nonetheless entitled, to make submissions on sanctions, and they weren't afforded that opportunity because they were said to have waived their rights. That's really the argument
Was
by
that at the
absenting
time
themselves.
that one of your clients referred to it as a kangaroo court?
Yes, I think so. Wouldn't be the first time that those clients of
No,
mine
it's
use
after.
colourful language.
Was it not after?
Gosh, I didn't realize that.
That
Okay.
was at the merits, isn't it? When
Pardon?
they- at the merits part of the.
Yes,
of the
exactly.
Yeah, yeah,
And
yeah.
then they reach their conclusion.
And then
that
you're
they
saying,
reached.
at that point, if I can get your submission, sorry, carry on. No, what you're saying is, at that point, the rules are clear.
Yeah.
You convicted them, you say these people are in contempt.
Yes.
However, having said that, they are now entitled as a separate leg of the inquiry
Correct.
to provide representations insofar as sentence is concerned.
Correct.
And your submission is they weren't given.
They won't. And that's because of this doctrine of waiver that is
And you were going to
applied.
give us a couple of references. I
Yes,
think.
that's right. Can we go to FA, is it FA 19? Okay. Apologies for
No,
that.
that's fine.
I was getting the detailed factual submission. So can we maybe start at FA 19,
Would you
At-
find again?
258 to 259, in that same volume that we were in?
258, 259.
Yes, please.
This is a letter from Mr. Levitt.
Well, from Mr. Levitt's firm.
Yes,
and
yes, yes,
Ms.
sorry.
Cupido,
yes.
yes.
Yes, it's from
Correct.
Miss Cupido.
Yes.
I do
So-
apologise for having called Mr. Cupido.
It's
I do
it's
apologise.
fine. I'm sure she's been
It
called
reflects
worse,
a terrible
but,
sexist approach which I'm
that's
very
okay.
embarrassed
Very bad.
since I'm sitting with two colleagues.
Absolutely.
And in fact, if you are going to, you should call us miladies because there are two of them and one of you.
Yes, yeah.
Justice
Anyway,
Davis,
carry
if you
on.
want me to call you my lady, I'm more than happy
I'm
to
more
do
than
so.
happy
You just
if
have
you're
to
going to call us
direct me and I'll
collectively,
do
it's
what you say.
miladies. Yes. No, seriously, it is.
Okay.
Take us to the letter.
Yes, so this is factually how it happens, right? My clients absent themselves from the hearing, which is, if you look at the letter, the date of the letter is as the hearing is concluding, okay? Paragraph 1 at the bottom of 258 talks about the hearing continuing in the absence of our clients. Now this is where our clients have not yet been convicted, okay? And then our clients say, we have instructions to make submissions on the evidence that was led yesterday, and we ask the committee to consider those submissions prior to making its determination on the merits. So, before I move on, maybe we should go to the founding affidavit and to contextualize properly.
Sorry, just that I got the sequence right.
Yes, yes.
We're back to the merits now,
Yes,
not
yes.
the sentence.
Yes.
Yeah, I'm just demonstrating this. Can we go to page 46?
Must read this at 46.
Yes, please. Page 46.
Mm-hmm.
So you can see, for example, at paragraph 111 of that page, that's the summary of why the conviction shouldn't have happened. But I want you to look at 112 at the bottom of the page, please. Prior to the committee making its decision on the merits, a letter was addressed by our attorney requesting the opportunity to make representations before the committee renders its decision. The decision is the conviction, for lack of a better phrase. Letter was sent. Then look at what it says there about when the hearing commenced on page 47. When the hearing commenced on 21 November, the initiator brought our letter to the attention of the committee. Initiator submitted, this is Mr. Katz's advice, that they were making an indulgence. And then the committee ruled that it would not be entertaining any submissions made by the EFF and that it would effectively to proceed to hear only the version put forth by the initiator. Any submissions to be made by the EFF were to be ignored. Can I pause there? That's the narration of the facts of what happened where my clients, through Ms. Cupido's letter, says, please may we make the submissions before you convict us. Whether for good reason or bad, or opportunistic reasons or not, at FA 18 in that bundle, at page 243, you will see the submissions, those submissions. So despite the committee saying whatever the committee said, my clients put the submissions in front of the committee ignored them. Okay? But that's a conviction issue. We were talking about sentencing, and I'm coming there.
Yeah, because I did read this, and a lot of that had to do with what we've just canvassed about whether it was threatening or not.
Yes.
Yes, yes, yes.
Okay.
Carry on.
but then, if you go back to page 47, because the narration continues, you see that at 117 it says the committee not only refused to take the EFF submissions into account in its deliberations, but also proceeded on 22 November 2023 to decide on a recommended sanction without giving the applicants an opportunity to present mitigating factors before it reported to the NA. And then over the page 48, the EFF was always entitled as of right to make those submissions in terms of reading section 9. And that is because if you look at page 118 on that same paragraph, the NA rules clearly state the process of determining a recommended penalty is distinct from the merits, meaning the committee was required to give us an opportunity to be heard regardless of whether we participated in the hearing.
And that goes back to 9 in...
Yes,
what
yes,
is that?
penalty.
Yeah,
That's
the
right.
Must.
Yes,
The
the must.
Yeah, right.
They say in response, the applicant's contention that they were 421, paragraph.
Thank you, my lord. Is that the answering affidavit?
Yes, 263. The applicant's contention is that they were entitled to straddle two horses at the same time as misplaced. Plainly, applicants had made an election when they labelled the committee a kangaroo court and refused to participate.
That's
They
irrelevant.
cannot therefore then claim to be entitled to participate on some semi-formal basis. This will be addressed fully in legal argument. Well, I wait for that, but I'm just saying that's their response.
That's their response. But can we just go back to the schedule then? Because that's a misreading of the schedule of the greatest of respect. Sure. If we go back to the schedule, let's look at what happens here. So look here. The page back, page 81, under the heading hearing. I'm not going to read clause 7. I want to draw your attention to clause 8. It says, if after receiving the notice is the notice of the charge, which is the merits issue, fails without just cause to attend the hearing, the committee may proceed in the absence of the member. Right? So that's how they reached their conclusion on conviction, because they say you absented yourself. What their argument has to amount to, in terms of this attempt to apply a waiver, a kangaroo court, and extricating yourself, is they have to read in words to the must in paragraph 9. In other words, that where you fail to attend, based on what it says in clause 8, that means you lose your right in terms of... Yeah. That's how they have to read it, and we say that's not correct, because why would the word must be there? Because must creates the situation that if you absent yourself from the hearing on the merits, that's the risk you take. The committee may go ahead without you, but then when it comes to the hearing, the sanction, that's it.
And if you refuse?
Which we didn't, but if you refuse, that's the risk you take. That must be the case.
Okay, but you say we never refused.
We never refused, we never got the opportunity. So it's even worse than that.
So the obligation moves to the committee.
Yes.
In 9.
Yes.
Yeah.
So your submission on this, just to round it up, is that when it comes to sentence,
yes,
we can argue the debate about whether, in fact, the committee was justified in granting a postponement with regard to conviction.
Yeah.
But what is absolutely clear is there's a peremptory requirement which would require a clear waiver, as I understand your argument, insofar as sentence, you were never given the opportunity in that regard. Okay.
And in the main heads of argument, we take this point. We demonstrate that there's no waiver.
No,
but
I've read the
I don't think that...
I'm
indebted. I'm not going to go there.
We've got the point.
Thank you.
We can move on.
Okay, I think I've already debated the committee's decision that the applicants are found guilty, and we've debated that already. The related decision, the committee's refusal to consider the applicants' written submissions. Because what we know, and if I can ask the court... go back to the schedule, page 81. I don't know if you've moved beyond the schedule.
We're there.
It's emblazoned in my mind.
Yours and mine both, Justice Davis.
Yeah.
But look at what it says in the tail end of clause 7 under hearing. It says, after all the witnesses have been called, the member or fellow member may sum up the evidence and make a presentation to the committee. So we would say that that's really the function of the merits submissions, which the committee ultimately ignored. and it ignored based on the evidence of Mr. Katsesi, because once you have allegedly absent yourself, then you lose the right to even put that in front of the committee. And we say
That deals with the merits.
yes.
Huh?
There is a difficulty, obviously, one should be careful about this, just in general terms. I mean, people can actually refuse to go.
Yes.
And, I mean, at some point, committee's got to do something.
Yes, no, that's correct. But I mean, and these internal contradictions are based on the wording of the schedule. Because if you look at the same page 81, it says, if after receiving the notice the member fails, comma, without just cause, comma. What's just cause? Is just cause only a medical appointment? Or you say that and Justice Davis, I do this, I tread very carefully. Is it because the Speaker improperly exercised her powers which gave rise to these hearings and therefore I don't recognize them? Is that just cause? So that's the point we make.
Okay, got you.
Thank you. I see it's almost lunchtime. I've got a few more submissions to make.
No, we're going to carry on for one. We've got another 10 minutes. Carry on.
Oh, is it 10? I've got 5 on my side.
No, we'll give you 10.
Yeah,
Okay.
5 more minutes. Sorry. Well, why don't we wait? You can use the 5 minutes.
Thank you.
You can wrap up after lunch, but
Thank
take
you.
the 5 minutes.
I'm indebted to the
Yeah,
court
yeah.
and the staff. Okay. Then, related to the first bundle of decisions, this is all in the context of the proceedings and what happened. The two things that we particularly take issue with is we take issue with the sanction that was recommended.
Yeah.
You'll remember that there were 2 parts to the sanction. One was the apology,
Yes.
and then it was coupled with
The 30 days.
the 30 days.
Yes.
And based on the earlier debate we had about how you read 12.5 and 12.9, what we say is that the evidence coming out in the answering affidavit as to how they reached their determination on that sanction doesn't find expression in the committee's report, in the recommendation, in terms, because remember, that's the obligation created by the Act. The Act says in 12.9, you have to engage with why the other things are inappropriate before you go to 5G. And they didn't do that in the report. And it's not open to them to justify this after the fact in the answering affidavit. So the point is that the sanction falls to be set aside because, to borrow their language, they try to straddle 2 horses. They make you do the apology, which is one of those things that could be a sufficient remedy under 12.5, coupled with everything else before G, and then they reach for G without telling you why G is applicable in the absence of everything else that they could have sanctioned my clients in terms of. So, insofar as the sanction, never mind the absence of Audi, which is what we were just debating about, must under clause 9 of the schedule, there's also here an internal problem in terms of recommending the sanction that they did because they failed to adequately discharge the onus on them in terms of the Act.
Got you.
I'm indebted. So that's everything that we were debating under 9.1.
Yes.
Well,
If we go back to that amended notice of motion that we forgot about a while ago.
Yes.
yeah,
That's
I
where
mean,
we were.
but that also covers what 9.2, doesn't it?
Well, up to the
First portion.
Yes. Well, I think,
the
it probably does both. With due respect,
No, it
Justice
does.
Fortin, it does.
No,
I think so.
absolutely.
I think so.
Yes.
And is the submission of 9.3 follow that if you've got an inadequate report under 9, as you've submitted, then the House couldn't have done its job properly?
Yes, that's right.
Is that really what that means?
Yes, but also it's in the it's additionally it's more than that. It's that, and again I tread very carefully when I mention EFF2. It's the EFF2 problem, because even if there is an inadequate report that serves in front of a majority that has an inbuilt incentive to punish you regardless, then that's the consequence that it's going to be. So that's the further difficulty that stems from that. It's never mind the nullity of the report, if we can call it that, for one of the review grounds of contending. It's that that report, regardless when it serves in front of the National Assembly, is going to be adopted, or potentially going to be adopted without any compunction at all.
What is the status of that report? Is it administrative action? Where does it fit in? What do we call that report? I mean, it's not binding on anybody.
The report between the committee and the assembly.
Yes.
Yeah, the report.
Yes,
to
it's
the-
recommendatory in
Yeah.
it's recommendatory in nature.
So
That's
does
right.
that mean they can reject it? They can. Is your
Yes,
argument
yes,
is it
yes.
unlikely to?
Yes, because it's
Because
an
of the
up-down.
majority.
Yes, because it's an up-down vote on the floor of the
Yeah.
House.
So your argument, as I understand it, would be that once the proceedings before the committee are, on your line of argument, as flawed as you submit they are, then the House is not legally entitled to proceed. Because at the end of the day, the suspension comes from the House.
Yes, yes, yes.
If you follow my logic.
No, I do.
I'm trying to
I do.
pigeonhole this.
The argument I just made to you now is my fallback position. My principal submission is that if the report can be vitiated on its own terms for breach,
And once that is, then you don't have a proper report before the House, and the House can't make the
that's the
decision.
first leg. The
Yeah.
second leg is that then, because of the up-down EFF2 type problem about majoritarianism, that's then the further breach of the
Okay,
rights.
I
Because
have you.
the House, because remember, the relationship between the committee and the House, usually, is that the majority on the committee is also drawn from the same party, which is the majority in the House.
No,
Yeah.
we have your submission.
So,
So as we take the lunch agenda, what is left, if I could just ask?
well, because if you don't give me the declaratory relief, then, as I said to you earlier, in terms of prayer 10,
All right.
I'm asking
Well, you
for it
can
under
mop up
review.
after. You can
Yes?
mop up after. That's fine.
Thank you.
Okay, let's take lunch agenda.
Before the Erasmus Court. So I do apologize to the court for that sort of wending way of the pleadings, but if the court, I'm getting indications that the court is appreciative of how the pleadings are then
Yeah.
going to work. I'm indebted to the court. My Lord Presiding, members of the court, may I just take a step to say the following about the history of this matter. What the court will obviously know is at the time when my clients were suspended from Parliament, there was a single party majority that controlled the structures of the House. That was the ANC. That implicates squarely the principles set out by JAFTA in EFF2. I don't know if it's helpful to take the court to that in the authorities bundle. Perhaps I can give you the reference. And maybe what we can do is if I can ask the court to take a note so that when the court then looks at this, when it has the bundles, the court will know it appropriately. The relevant paragraphs in the EFF2 matter, which EFF2 matter, citation 2018 volume 2 SA 571 CC, which I will refer to in these proceedings as EFF2, the relevant paragraphs are 192, 193, and 194.
You're too fast there, Council.
I apologize. My lady, what may I assist with? The citation or the...
192
The
pages.
page.
Oh, no. So the citation is EFF and others versus Speaker and others.
Yeah.
Another 2018,
Yeah.
volume 2.
It does make it a bit harder. But I mean, but when you're permanent control like that, you still might have friendships. I mean, you're working with colleagues.
Very busy.
But also, I didn't.
I'm earning my day fee.
And then they gave an order. I didn't give him judgment yet. Yeah. And then Gamble is acting. Gamble actually. Yes. He sends me this WhatsApp saying, "You know, this I really enjoy listening to you."
Silence is on.
Please do carry on, Mr. President.
Thank you, Justice Davis. Justice Davis, may I just address a matter of housekeeping first before I
Sure.
just deal with wrapping up? In the course of the pre-lunch session, where reference was made to those foreign extracts, what I've said to my learned friend is that we didn't simply want to just print that and hand it up. We wanted to do it under an index. And so we will prepare that and endeavour to circulate an electronic copy today so that our learned friends can address it tomorrow if they need, and that we'll bring
I
hard
sincerely
copies
hope we
tomorrow.
don't go on to tomorrow, as I indicated to you.
Yes, I'm not sure I can give you that assurance.
Well, I might be able to give you that assurance since I control the proceedings.
Yes, notwithstanding our allocation for 2 days.
Yes,
but
I know that, but
be
we're
that as it
basically at the
may.
end of your submission, so carry on.
Thank you. So that's the matter of housekeeping I wanted to deal with.
But there's not a problem with that, because frankly, if you want to put something up to them, both sides can give us a note accompanying it. It's not a difficulty at all. You don't have to waste time.
I'll take the direction from the court.
Within reason, we'll give you an opportunity for that.
I'll take direction from the
no
court.
question. Yeah.
I'll take direction from the
Yes,
court.
yes, it's fine.
Thank you.
Okay, so let's move on.
So, before coming to the question of costs, there's one issue that I just want to wrap up on, which we were debating just before the lunch adjournment, which was about the speaker and being a witness and what was in the charge sheet or not in the charge sheet, as the case may be. So, can I ask the court to please start at the charge sheet, which we've looked at already? And in particular, I'm looking at the Annexure A. So it starts on my side. One such copy can be found at page 93. Another such copy can be found at page 87. So you can look at any one of those. So if we look at the contempt of Parliament, it says, it is alleged that you are guilty of contempt of Parliament in terms of section 13A and C, read with section 7A and E of the Act. So I just want to stop there for a moment, and I just want to ask the court to bring up the Act. So I want to start at section 13 because that's mentioned first in the charge sheet, if that's all right. Internal page 7.
Yeah.
Where we now?
In
seven,
the Act,
7, yeah?
the Act was handed up separately. Can we?
I got it.
13.
13A and C, yeah?
Yeah, 13A and C. So a member is guilty of contempt of Parliament if the member contravenes section 7, 8, and the sections listed there. That's 13A. And 13C then says...
No, you said A and B. What did you say? A
No,
and
no,
C,
I said
sorry.
A and C.
Sorry.
Apologies, my lady. So 13A and then 13C over the page. Willfully fails or refuses to obey any rule, order, or resolution of the House or the Houses. So that's the first part of what is said to constitute contempt. And then the second part of what is said to constitute contempt is 7A and 7E. So if you turn back a couple of pages in the Act to internal page number 5, section 7A, a person may not improperly interfere with or impede the exercise or performance by Parliament or a House or committee or its authority or functions. And then lower down, while Parliament or a House or committee is meeting, create or take part in any disturbance within the precincts. So that, in terms of the Act, is what is said to be the contempt. With that is reliance on the rules. And the rules which are referenced, and if you turn over the page to page 88, I think it is, the rules that are cited by the National Assembly, well, by Parliament for the purposes of this charge are rules 64A and D, as well as rules 69A and F. Now, I'm not sure if the court has those rules in front of the court. May I just get an indication if you have those rules? I think there's only the extract from the rules which we talked about, which is the schedule and rule 213.
Yeah.
May I make a suggestion? We're going to be doing these parliamentary extracts, which we'll hand up to you. We'll also hand up a copy of the rules.
Just read them to us.
If that's okay. I would read them to you if I could find them on my side. I've just temporarily mislaid them. If the court will bear with me. Here we are. if the court will please bear with me.
Sure.
Oh, here they are. I apologize.
Okay, carry on.
They were hidden under my file. So, 64A. 64, conduct of members. Members must at all times accord the presiding officers of the National Assembly and members due respect and conduct themselves with dignity and in accordance with the decorum of the House, and are required, sub A, to enter or leave the House with decorum. That's all it says. And then sub B, not during proceedings to pass between the chair and the member who is speaking, nor between the chair and the table, nor to stand in any of the aisles or cross aisles, nor to cross the floor of the House in front of the benches. So that's the 64A part. And then the 69 part is 69A and F. And that says as follows: grossly disorderly conduct. Members may not engage in grossly disorderly conduct in the House and its forums, including deliberately creating serious disorder or disruption. And then F, acting in any other way to the serious detriment of the dignity, decorum, or orderly procedure of the House. So those are the things to which the contempt charges are set.
These were the sections upon which the facts were then predicated.
Yes.
Well, yes, clearly.
Yes.
So, and where does this leave us?
The point that I want to make in the context of these proceedings is, firstly, when it's common cause that the committee only called one witness. That one witness was Mr. Kaso. The reference to that is at page 40,
No, we know
para
that.
We know
84.
that. You don't have to. We know that. I've
Thank
read that.
you.
And I've read his evidence. Yes. carry
Thank
on.
you. Then what I want to ask the court to have regard to at FA, I beg your pardon, I just want to find the other reference that I was looking for. In FA 18 is the submissions of the charged members in front of the committee. This was about their submissions on conviction. FA 18 starts at 243.
243,
Yes.
please, yeah.
Whilst you've got your hands there, can I ask you to turn into that annexure at page 246, at paragraph 8. So remember, this is the sole witness that the committee relies upon in order to convict for contempt of Parliament. And what does the witness say? The witness says, I am here just to explain the roles and procedures of Parliament. It is not really for me to express an opinion there. But Chair, with your permission, I will not express an opinion on what is likely to be the finding of the committee on this matter. I just express my view on the application of the rules. Now, I'm not sure if he is entitled
Now, I'm
to
not
do
sure
that.
whether this takes us any further than what we had before, which was your point, which I understood. I need to consider, speaking for myself,
Sorry.
that the Speaker and the President should be called
Yeah.
to give evidence in relation to
I'm-
the threatening,
I'm-
and that's exactly what Mr. Malema tells us.
All I'm doing is I'm just giving you the references in the
I got
report
that,
to
and I
cross-reference
understand
that.
that, and I perfectly understand that. I just
Thank
don't
you.
want repetition of what we've already known.
No, I'm not repeating. I'm just
Okay,
giving
I
you
just merely
references in the
mentioned-
record
Yeah,
with
all right.
respect. And then what you know in the context of that witness's evidence, apart from the fact that that witness tells you that it's not for them to give an opinion
Yes, of
because
course,
they're
and he
obviously
can't
not the
say- yes,
presiding
I agree.
officer. The necessary consequence of the failure to call the Speaker as the presiding officer, because remember, these assessments in terms of the rules are primarily done by the Speaker when the Speaker is sitting as the presiding officer at the relevant proceeding where they are said to be breached. The necessary impact of the failure to call the Speaker and the necessary consequence of the failure to allow the Speaker to be subpoenaed is that, firstly, and as I've submitted already, we say that the committee then never met the onus insofar as proving the charges, because remember, the only witness says, I'm just here in a technical capacity to tell you about the rules. It's not my role to tell you an opinion because that's not the presiding officer. So that's the first point. The second point, obviously, is that denudes us of the duty. Well, firstly, we must accept that in the context of adversarial proceedings like this, we have a duty to cross-examine. But if you don't call the necessary or available witness, we're denuded of that ability to cross-examine, which has the impact then of not being able to advance a version in favor of our clients. And what we also know is we know that the speaker in her own right is a material witness, not only because of her occupying the chair at the time that these breaches occurred, but also because of the threatening issue which we highlighted earlier, as with the president as well. May
I promise you, I've got understanding.
I'm perfectly aware that you might have that, Judge. I'm following my instructions in the context of
well, you can tell your
putting
instructions
the
that,
subject before
you
the
know,
court.
unlike good wine, it doesn't just get better with age, we understand.
Yes. Anyway, notwithstanding your lordship's enophilia, what I will then say on the question of costs
Yes.
is that in the context of this dispute, we say that Rule 67 is applicable and that Scale C should apply, and the reasons for that are self-evident arising from the debates we've had today. This is a particularly complex matter. Both sides have employed two counsel. It's a constitutional issue. Insofar as whether or not, if my clients are unsuccessful, and whether or not costs should be mulcted against us, let me say this. In respect of the Erasmus Court and the Savage Court, we had adverse costs orders against us because the court was willing to accept that our conduct, or my client's conduct, in those proceedings amounted to an abuse of process. However, in the context of this Part B in front of this court, there is no equivalent argument to be met that this is an abuse of process. This is a fully vindicated...
So should costs follow the result?
Well, if I'm successful, yes, costs should follow the result.
And what happens if
I'm not successful, I'm saying Biowatch should immunize us.
Go Biowatch,
Biowatch,
yes?
because we don't meet any of the thresholds of the exception in terms of affordable medicines. It's not vexatious, it's not frivolous,
Okay.
it's not for a spurious purpose.
Okay, got you.
No, you shouldn't look up yet. Turn back.
And then Ms.
Turn
Naidu,
back. Yeah.
those are our submissions for the time.
Thank you very much.
Thank you. As the court
And we're
pleases.
indebted to you. Thank you very much. Right. I think I don't want to, again, short-circuit you, just like I didn't want to short-circuit your opponent, but I think it's pretty clear what the issues are.
Yes.
Yeah.
I've heard the debate, and what we are proposing to do is we've divided the argument up. So the proposal is that I will deal with the constitutional challenge, which is paragraphs 6 to 8 of the amended notice of motion, and Mr. Bishop will take the rest, which is paragraphs 9 to 11.
That's
And
fine.
I've heard the debate on the constitutional challenge. So over the lunch adjournment, I've actually truncated my argument quite a bit, and hopefully I can be
Carry on.
more succinct than I thought I would be. With the court's leave, I will
Succinct
address...
is always good.
I beg your pardon?
Succinct is always good.
Yes. With the court's leave, I propose to deal with 4 topics. The first topic is the outsourcing to an independent body, and I've heard the debate, but it is still a live issue, and I want to cover it nonetheless. The second issue, which is a key issue in the case, is the issue of bias. And the third issue is the issue of discretion. And there's 2 legs to the discretion, which is the first leg is the guidelines are needed for the sanction, and guidelines are needed for the process itself.
Yeah.
That's the discovery, etc.
Yeah.
And the fourth topic is the section 12.5 of the Act. But I would have covered that when I get there.
So.
But it is a self-standing prayer in the notice of motion, the amended
That's
notice of motion. I was going to deal with the litigation background, which I don't need to deal with. I have brought copies of the 2 judgments in the interdict applications, hard copies, if the court would like copies of that.
Yes.
Are you talking about the judgments of judges?
The Savage and
Erasmus.
Erasmus here.
I have copies if the court wants them. I'm not going to refer to them.
I've got, yeah.
Do you have it? I was looking for the Savage one. It
I've
wasn't in
got
the
the
papers.
Erasmus one, and then I do have the other one. I found it last
Yes.
night. and I
Perhaps I
searched
can
it.
just, for good order, I can hand it up, and
Yeah,
the court
sure.
may disregard them or not.
Sorry, is the second one, just to make it good, you talk about the Savage, is it not Sure?
Yes.
Sorry, I
Yes.
meant Savage presiding.
Savage court, yes.
Savage was...
But
Savage,
Sure J wrote the judgment.
No,
Yes.
I know, sorry. I was...
So I am right, because
No, correct.
at least I'm right about one thing.
Yeah.
So,
Correct.
So,
Sorry, I was
so
referring
yeah,
to
yeah,
the...
I have, I don't know if you don't have,
I couldn't find it. I've
okay,
lost
just
it.
have a look.
Missed
There we
it.
are. Okay,
Here we go.
all right, very good, I've got it.
Yes, so I was just
I'm
referring...
not sure that they add anything
No,
to
no,
it.
no, no, no.
No.
No, I was only handing it up.
No, thank you.
Yes, no,
Thank
I'm
you
not
very
referred
much.
to it at all.
No.
The one thing I do want to highlight, and it's with leave of my learned friend, is that when I printed it out my copies that was on my laptop, and I highlighted on the PDF.
Yes.
So you will see in one of those,
Yes.
there's highlighted versions. I apologize for that.
Well, if you
The
have-
friend doesn't have a problem with it.
No problem at all.
And I'm just-
Then all I can say is you haven't said anything rude about the judges and stuff.
I hope not.
Okay, carry on.
Yes, Judge. If I then may move on to the issue of the independent body.
Yeah.
The central question here is whether Parliament has the power or the power must be outsourced to an independent body. We submit that it's obviously Parliament, and we make the submission for three reasons. It's supported by the constitutional framework, and it's mandated by the constitutional framework. It's also mandated by the Act because the Act says so, and they don't attack the Act. Sections 12, 1, 2, and 3 of the Act is not attacked. The second reason is that there are two judgments of this court which are on point. That's the Tsalama judgment, and that's the EFF judgment, the full bench of Lord Law.
Yeah.
And the court has that. And the third reason is the foreign law. And I'm not going to deal with that because of the debate that I've had earlier, but I do want to make the following point, is that Mr. Bishop is very eager to address the Boris Johnson issue.
I'm always happy to hear Mr. Bishop, so I assure you.
Yes,
I'm happy
yes.
to hear all of you, but I'm more than happy
Duly
to hear.
noted.
Yes, none of us take offense. But he's very eager to deal with Mr. Boris Johnson, and so
The
he will deal with
best
that.
democracy that we can look at.
Exactly,
currently.
exactly. So
Yes.
he will deal with it under the foreign
That's
law aspect.
Oh, yeah, we refer to it.
Yes,
Yeah,
yes.
yeah.
Okay, carry on.
Very well.
Yeah.
So I don't need to deal with the constitutional framework other than it's obviously sourced from sections 57 and 58. The court has those in the heads. What I do want to just highlight, and it's just very brief submissions with regard to the Act, I want to highlight the preamble to the Act, which is, just puts it with respect beyond a doubt. In the preamble, it says, it's the third whereas. It says, whereas it is considered essential to provide for such further privileges and immunities, and in order to protect the authority, independence, and dignity of the legislatures and their members, and to enable them to carry out their constitutional functions. So that's the framework of the Act, and how they do it is enforcement of Section 12. That gives the teeth to the Act, and as we know, they do not attack subsections 1, 2, and 3. The notice of motion only deals with the rules, and we submit that's fatal to this argument of institutional bias, because that's totally dispositive of that. And you cannot delegate on the basis of the Lord judgment, and we've covered that. But you also, I just want to emphasize this, also they do not attack Section 12.5. 12.5, there is an attack to 12.5, but not in the context of proportional representation and outsourcing. The attack is something different. It's about the guidelines. So that's also a further basis on why that argument cannot succeed. And then I just want to emphasize...
So just so
yes.
I can get this clear, because I think I had this exchange. It's this, that because 12, 1, 2, 3, and 4, etc., are not attacked,
Yes.
the structure of that provision, which envisages Parliament having an internal set of processes itself,
Yes.
isn't being called into constitutional question
Yes.
by them,
Yes.
and therefore one has to take that as a basis for justifying your submission,
Yes.
that outsourcing, one, wasn't envisaged in the Act, two, it's not really under attack because you have to attack the whole thing in order to get there. Is that
Exactly.
right?
100%
Gotcha.
correct.
I just need to understand
That's
that.
the submission. That's
Right?
the submission.
Thank you.
And I don't want to belabor the point.
No.
If I may then I just want to, the court did correctly address the issue of the EFF judgment I'm talking about, the EFF 2. That's the 2018 judgment of the Constitutional Court. I just want to add two submissions on that. What happened there was the argument on behalf of my client, the speaker was, the parliament, framed that way, was that the ad hoc rules were sufficient for this to fill the vacuum, because there were no specific rules. That's what the case was about. And the court said, no, you must have specific rules. But that doesn't arise here, because we do have specific rules, because those are rules they attack. And also the very fundamental distinction between that case and our situation, and also, ironically, the foreign law, is that we do not have removal. You cannot remove and expel, same thing essentially, a member of parliament. That is not envisaged by the Act. The high water mark of the Act is suspension, and suspension for 30 days. And it all flows, all of that, all sanctions, and I want to emphasize that, flows from one offence, contempt of parliament. It's only one offence, there's no other offence. If I then can move on, I've dealt with the outsourcing. If we can then move on to the issue of bias. And the whole argument is premised on this notion of the tyranny of the majority.
Yeah.
But we know that is democracy. Democracy
The
is
nature
the
of the
majority.
beast,
It's the
isn't it?
nature of the beast. We cannot shy away from the majority. But that's what they want. But again, they do not challenge, I want to emphasize the following, they do not challenge in this context sections 12, 1, 2, and 3, because they're based on proportional representation. And the same with 12.5, because 12.5 of the Act makes the House, Parliament, the decision maker. The committee is just the fact-finding body. It tables a report, it votes on it, and then it gets passed on to the House, and the House then does the same thing. The House votes on it. The House is the decision maker, but the House is made up of proportional representation. But they don't attack it, so that it does not assist them.
Which is where it originates, the whole process.
Sorry,
It originates in the House.
Yes. No, sorry, yes, you're correct, sorry.
Yes.
Yes. And it
So
gets
if it's
referred
not
to the
attacked,
committee.
yeah.
Sorry, yes. Yes.
Yes, yes.
It gets referred to the committee. The committee does the fact-finding, but they're both based on proportional representation.
Yeah.
So the bias argument, if the bias argument is good for the one, it must be good for the other. But they only raise the bias argument on these papers in relation to what I'm going to call the first leg, which is the committee. But it doesn't assist them because the National Assembly is still going to vote based on proportional
Well, I
representation.
think their argument is that precisely because there's an up and down vote in Parliament, you want to be particularly careful about the input that is made to Parliament for its up and down vote, and that therefore you'd want to eschew bias if you possibly could in that connection. I think that's their submission.
No, the submission.
And since the Prime Minister has been nodding, I've got him right. So clearly in relation to what he's saying. So I'd like to know what you say about
Well,
that.
the submission is, the argument as we understand it is the complaint is that, and they say this on the papers, it's the ANC majority. That's what they say. But that is not, that as they say, a week in politics is a long time. But these papers were issued in November 2020. 6 months is a whole other universe. When they launched these papers, the argument was, and it was based on proportional representation of the ANC having 57%. And I'm dealing with this obviously in the context of the constitutional challenge.
Yes, it's rather,
Yes.
yeah.
Just making that emphasis because the next point I want to make is that when you raise a challenge of this nature, it must be objectively unconstitutional. But as we stand here, it's not the same scenario as it was then. Because we don't know who is going to be in the majority. Now,
Well,
as we
this
sit here,
strikes me, if you take the logic of it all, which is where this whole thing becomes polycentrically problematic,
yes,
is if you took the situation now, assuming, that somehow we get into Parliament within, 10 or 11 days, whatever it is, at that point, if you took the proportionality and you took a committee of this kind, the ANC, assuming you had 10 members, the ANC gets 4.
yeah,
Right? The DA probably 2, Mr. Zuma's party probably 1 or 1.5, or together with the EFF 1 and 1, and maybe the others, IFP.
yeah.
So the irony would be, you could argue that actually, if it's that all the other parties are going to gang up on one party, you get the same problem. In other words, what I'm trying to say is, the problem becomes insurmountable once you move beyond proportional representation, because if you took 4 plus 2, right, meaning 4 for the ANC and 2 for the DA, on the logic of the applicants, well, since those two parties are opponents of the EFF, they would be, it would be in their vested interest to get the EFF out of Parliament. Doesn't really make much difference, does it? In other words, what I'm trying to say is, I'm not sure what system would apply.
Yes.
Which is not against you, in fact, you're looking at me quizzically, but it's the problem I'm trying to articulate. Judges need to think through what the order, the consequences of order are going to be. One of the big problems that we have in our jurisprudence is that doesn't happen all the time.
Yes.
And I'm worried about that.
Yes. And well, we know what the answer is. We know the answer from
The answer is that the proportional representation, for good or bad, is the one.
It's the
It's
system.
been, exactly,
It's
it's been,
what
it's
we
been
have.
chosen by Parliament. It's what exists in the Constitution.
Yeah, I'd be
Okay.
particularly interested if the EFF had got 50 plus 1, whether they'd still be arguing this.
Yeah,
Yeah.
well, we've raised that point.
You don't like the system, you don't.
No,
Exactly.
I don't want to waste time. I understand
Exactly.
where you're coming from. Okay,
Yes.
let's move on.
I just wanted to make the following
No,
points. Yes,
I'm indebted you did because I was trying to think through the consequences.
as the court pleases. The one point I want to make is that section 12.5 is also the same thing. The proportional representation, the court has the argument. The other point I want to make is that the test for bias is an objective test. And what they're actually saying is that subjectively, you are my political opponents. And they say the ANC has never disciplined its own MPs, its own members. But that's not correct in the facts, and I just want to give the court a reference to that. That's page 377.
377.
377. I don't want to take the court there.
No, we read.
Yes, I'm just giving the court a
Remind
reference.
us,
It's
yeah.
page 377, para 122. And then we also know, the court can take judicial notice of it. We also, the speaker, the previous speaker is also being disciplined, and she's a high-ranking member. She's also coming before the committee. So it's not a case of no, because their case is that this has been used as a political body to discipline the EFF members. That's
Your point, as I understand it, is that the record shows that far from being inevitably skewed in favour of, say, a majority, that doesn't always work the case, because one should have more confidence in one's MPs to follow their constitutional duties. Is that
yes.
really?
Well, yes. I'm going to get to the second leg of that. But
Yes.
that's correct.
Got you.
That's correct. And then also, the argument is actually, the answer is a philosophical answer, which is, it's Occam's razor. If the reason that the EFF has been disciplined is because they've behaved. That's why they are the one party that's been, and members have been disciplined the most. That's the simple answer. You can't want to raise the argument and say it's biased when that's the actual answer. The other point I want to make is, and I just want to tie this up, was dealing with the point of the majority then and the majority now. The point I wanted to make was that the Ferreira versus Levin point, which is you've got to test this on objective grounds. A provision can't be constitutional, unconstitutional yesterday, constitutional the next day, and thereafter somewhere in between. It must be objectively unconstitutional. And that's why when you use the facts, when the case was initiated in the facts now, they're different.
But
And they
that
undermine
mean-
the argument.
But let me just test that. Would you therefore be saying the test is a reasonable litigant?
Sorry?
Is it a reasonable litigant test?
No, sorry, that's
For bias.
For the bias.
Hmm.
For a reasonable litigant.
Well, in
No,
other
but
words,
it's
what I
not.
mean by that, if you look at, for example, when judges have to recuse themselves,
Yes.
I mean, we've just had that particular experience in a case very recently.
Yes, yes.
Right? And the court quite rightly
Did not
set out the
recuse
law
themselves.
from the President of the Republic of South Africa versus
Yes.
Louis Late,
Yes.
and said, well, what would a reasonable litigant or a reasonable person looking at this come to the conclusion? Is that the test for bias?
No, well,
Because if it is, you see,
yes,
if it
Yes.
is, then could it not be argued that I'm a member of the EFF, well, I've got a reasonable apprehension that these people are going to put the boot in?
So there's two answers to that. The first one is that the argument that they're raising is institutional bias. That's the first one. It's not bias in how we know and understand.
Ah,
It's
see, it's
that's-
a structural
It's
conceptual
a structural.
bias. Oh, gotcha.
It's
okay.
the
Thank you.
partisanship of
Right,
it.
okay.
That's the
Fair
argument.
enough.
And then I just want to add this as well. The irony of it is that they never actually moved for a recusal. They moved for a postponement application based on institutional bias, essentially.
Yes,
And
yes.
that you'd have seen from the written submissions.
Yeah.
And they gave the written submissions, and they said we want a postponement because they want to go and litigate elsewhere, and they called the forum a kangaroo court based on institutional bias.
Thank you.
Sorry, can I just give the court a reference of the Ferreira versus Levin decision?
Yeah.
It's Ferreira versus Levin in 1996, 1 SA 984 CC, and it's paragraphs 26 to 29.
Is that the judgment, is that the Shaskelson judgment?
Yes,
or-
that's correct. That's
As
correct.
opposed to
No,
the Ackerman judgment?
Yeah.
Ackerman.
Shame, who just died recently.
Yeah, it's one of our colleagues' father.
Yeah, yeah,
Still at the moment.
yeah.
Then I just want to give the court another, before I move on from the topic, because I'm on the last section almost. When you deal with, the argument is essentially unfairness when they're attacking the legislation. But you can't attack legislation based on unfairness or fairness. And the authority for that is the Cool Ideas case. And I just want to give the court a reference to that. It's a paragraph 52. I don't know if I must give the full reference. Well, it's Cool Ideas versus UBARD, 2014, Volume 4, SA 474.
Sorry, 2014?
Volume 4, SA 474, CC, at paragraph 52. And now, I want to just deal with...
I'm afraid these days you better to give us the actual
Yeah.
judgment date because judges don't get the law reports anymore.
Yes. Perhaps I should have given the Safri reference then.
Yeah,
But I don't have it at hand.
But I know
But,
good ideas.
you know, it's a simple
No, I
proposition.
know the case very well.
Yes.
Carry on.
If I may then just summarize this argument, and I'm dealing still with this issue of bias, and I just want to summarize the argument with regard to the oath of members. And I'm going to make the following points. The oath you will find at section 48 of the Constitution, read with item 4.1 of the schedule, schedule 2. And then the judgment, and again I apologize for not having a copy of the judgment, but your Lordship, Justice Davis was referring to the judgment about the oath supersedes it's the secret ballot.
yes.
That is the UDM versus
It's the
Speaker.
UDM, not the Democratic line.
Yeah,
The reference is UDM versus Speaker 2017.
Hang on, I want to get that so I get it right this time. UDM versus?
Speaker
Yeah.
2017, Volume 5, SA 300 CC at paragraph 79.
Thank you.
And then to add that, and it is, sorry, I didn't hand up my bundle of authorities. The other reference to the issue of the oath is the Tolamo versus the Speaker judgment, which is in the, and it's quoted in our heads at page 21, paragraph 62. And that obviously, that case dealt with the Speaker, and they challenged the impartiality of the Speaker because she was a member of the ANC.
Thank you very much.
Said no.
Yes.
If I then may move on to
We now on to discretion.
yes, I seem to have muddled up my notes. The court can just bear with me 1 second. I can then deal with the discretion.
Yeah.
And there's two legs to the, well, they say you need a discretion, and it's essentially on the basis of bias. And you need guidelines to guide the sanction and the process. That's the argument. But Your Lordship, the court has my submissions on bias. So that covers that. And then we make the following submissions with regard to the sanction and why guidelines are not necessary. The first submission is that flexibility is important and is necessary with regard to the sanction. And it actually promotes fairness, the flexibility of not having guidelines and not straitjacketing the committee and Parliament. And also, I just wanted, the argument that was raised earlier was we in Darwood situation. What we're not in Darwood In Darwood, there was no framework. That's the first point. The second point is, in Darwood, you were dealing with a low-ranking immigration official at an airport. You're not dealing with a low-ranking official in these circumstances. You're dealing with an MP. And yes, there is no strict qualification, but there is an oath. And a lot of the MPs we're dealing with are seasoned MPs. I want to emphasize the following is that we're dealing, and I made the point before, but we're only dealing with contempt, so there's only one offense. So, because you're dealing with one offense, you need to deal with that on a specific set of facts. And that's why you can't straitjacket this in the way that they want, because it must be fact specific. You must allow for that flexibility in order to apply which sanction in which context to the offense of contempt. And it's also hard to regulate via guidelines. And an example of that was the debate that occurred earlier about what else should you do? What more could you do? And then again, we get in a difficult scenario of the bait or star scenario, which is you don't want to overstep and dictate to Parliament, a separate arm, how to regulate the process. And we know where the court function comes in. The court's function comes afterwards. So that's why it must be fact specific. If Parliament does not exercise its powers lawfully and rationally, then you must come to court and you challenge it on those facts.
So
And
essentially, sorry to interrupt the counsel, essentially you're saying there's nothing wrong with self-regulating.
no. Yes. In fact, it's mandated. That's the nub of our argument. It's mandated from Section 57 of the Constitution. It's mandated by Section 58 of the Constitution. And 58 mandates the promulgation of the Act. And they don't attack Section 12, 1, 2, and 3. So all of that points to a situation where it's self-regulation.
In fact, just to make sure that I understand your response to my sister, what you're saying is it's not just not bad, it's effectively the structure of the system. Bringing us back to your earlier submission, that unless you attack the whole of Section 12, you have to accept the validity of an internal structuring process.
Correct. Yeah. Correct. Because that's why I started with the preamble. The preamble refers to the dignity of Parliament, and we're dealing with contempt of Parliament.
Gotcha.
So it's similar to a situation which is the process. You need guidelines for the process. Again, the linchpin of this is bias, and the court has my submissions on that. The other submission is, and only one of my 3 submissions, the other submission is we're not dealing with the court here. Because what they're trying to do is they're trying to create a court system, discovery, cross-examination of witnesses. But again, this has been dealt with by the full court in the Dlodlo judgment, and I'll just give the court the reference. It's page 53, paragraph 44 of the judgment, where the court says, perhaps we can just...
No, I've got it in front of me.
Yes, perhaps I can just read it for the...
Yes. Paragraph?
44.
Yes, but it starts, the section I want to read from is at
Here we are.
page 54. It's the sentence that starts evidently. Evidently, 350 to 400 members of the National Assembly do not sit as a court of law. And let me just stop there. This is not new. We know this from the Harris decisions. We don't deal with the High Court of Parliament. So they don't sit as a court of law. The National Assembly, as the House, cannot practically or procedurally make or define findings of fact in the same way as a court of law does, or would it be expected to do. It is unfair and contrary to reality to expect that the National Assembly should have gone about and documented findings relative to sanction in the manner that a court of law would. So you can't, it's an inapt analogy. And we do embrace the argument about what happened in the Public Protector. It was, we all know, unfortunate, and Mr. Bishop and I were involved also, and still are involved, in fact, in some of the litigation flowing from the Public Protector. And that is not what it should have been. It should have been a short process, not involving counsel at any stage with respect, but we must live with that. But there's a reason for that. It's a specific scenario that happened in the context of that. But it's an example of why we should not have the same process. And there's nothing wrong with that. If I can then deal with, I've dealt with the attack on the process. Sorry, just go back. The final leg is section 12.5 of the Act. Sorry, there was the time bar issue. I just want to make two submissions on the time bar. One is, again, it's covered by bias. That's the first one. Two, it doesn't arise on the facts. Because we've given an answer for the time delay, let me put it that way, on the papers.
Yeah.
And I just want to give the reference to that. That's in the answering affidavit, page 346.
We were not addressed on that.
Excuse me?
We're not addressed
No,
on
we
on
were,
that.
we were. We were in the fact that Ms. Mamid said that we should be a time bar, no question.
Yes, sorry, I just...
That was it. I mean, on your submissions,
Sorry?
was not raised. Yeah, the explanation you gave.
Yes, no, yeah.
Where is that, sorry?
That
It's
is
in the answer.
The
Yeah.
answering affidavit
At?
at page 346 to 349. It's paragraphs 45 to 51.
That's the chronology that is
That's the
happening.
chronology of
Exactly.
why it,
So
yeah.
you can see from the chronology that it wasn't
No, we've
intentional,
got
it
that.
wasn't egregious, and that's the submission.
Mhm.
Yeah.
So it doesn't arise. The last point I want to deal with is section 12.5, and I'll be brief on this because I've covered this.
Before you get there,
Yes.
counsel, I think their gripe is they were not also afforded sufficient time to prepare.
Well, they don't attack the provision in the rules. The provision in the rules says
5
that they
days.
must get 5 clear days. They've got more than that, so they didn't attack that. So that's the first proposition. The second proposition is that when you look at what they were given 640 pages. That's what they say, and we couldn't read this. But when you actually look at the documents, it's not what they purport to be. It's not 640 pages of new documentation that they couldn't read and couldn't prepare for. That's the, with respect to the answer.
Yeah.
Yes, sorry, and I don't want to take the wind out of my learned friend Sale, but he will also cover that when he deals with the postponement, because there's a regular consideration for that.
Yeah, yeah,
If, with the court's leave, if I may then deal with the final topic.
yeah.
Section 12.5. So this arises from paragraph 8 of the amended notice of motion, and the argument essentially is that it's a similar argument to the other arguments, which is there's insufficient guidelines for the National Assembly with regard to sanction. But again, the answer is, well, a bias. It's the first answer. I know I sound like a struck record, but that's the answer. The second answer is that, and it's the point that was raised earlier, it's section 12.9. They do not attack section 12.9. And section 12.9 does give guidance. It gives guidance on the basis of seriousness. And they don't raise on these facts. Remember, it's the constitutional challenge. They don't raise on these facts that it's not serious. In fact, the argument is they don't attack section 12.9 at all. Justices, those are essentially my submissions, unless there are further questions from the court.
No, not.
Thank you very much. Mr. Bishop.
Thank you, Malema.
Yes, I've always insisted on this. No, he's not. He's got one up here on everybody. Mr.
Yes.
Femi didn't do that, you did. Tick, tick. Carry on.
I'm going to address the review grounds, or the various review grounds for the process that the Committee and the National Assembly followed. And I'm going to first just talk very briefly about what the standard is that this court should apply, and then go through each of the pleaded review grounds. And I'm going to take the court through the founding affidavit where the grounds of review are pleaded, because what you heard earlier this morning is very different from what's in the founding affidavit. And those are the grounds of review that we called the court to meet and that we're going to answer. I'll then try and deal with the additional grounds that have been added along the way. But I'd like to start by dealing briefly with Mr. Johnson. I have prepared copies of the report that the Parliamentary Committee in the UK produced. And I don't want to take the court through it in any
Never
detail.
did I dream in my wildest dreams that I'd have to deal with Boris Johnson.
But I do just want to refer the court
Yes,
to a few specific portions, because I think they're revealing, because some of the same complaints that arise in this matter were also made to the committee in the Johnson inquiry. So if I can start at page 10, where there's a section on the procedures in this inquiry. And it goes through what the procedure is, and I would recommend that section of the court, paragraphs 10 to 16. But I want to focus on paragraph 14 on page 11. So it says, in bringing forward our report, we note that the committee was instructed to carry out this inquiry by the House on 21 April 2022 without a vote against. We further note that each of the committee's members were appointed to the committee by the House without provision. Each member has done their duty on behalf of the House. Despite this, from the outset of this inquiry, there's been a sustained attempt, seemingly coordinated, to undermine the committee's credibility, and more worryingly, that of those members serving on it. The committee is concerned that if these behaviours go unchallenged, it will be impossible for the House to establish such a committee to conduct sensitive and important inquiries in the future. The House must have a committee to defend its rights and privileges, and it must protect members of the House doing that duty from formal or informal attack or undermining, designed to deter and prevent them from doing that duty. We will be making a special report separately to the House dealing with these matters. We note that Mr. Johnson at no point denounced this campaign while it was underway. Giving oral evidence, he expressed respect for the committee and said, when pressed to do so, that he deprecated terms such as witch hunt and kangaroo court, but said the people would judge for themselves whether the committee had been fair. Asked in relation to the committee's inquiry, would you not characterize it as a witch hunt or a kangaroo court, he replied, I will wait to see how you proceed with the evidence that you have. Exactly these same arguments that this is a kangaroo court are raised here, and the committee goes through in detail to explain why that's not the case. If I can refer the court to Annexure 1, which is they go through each of these complaints that were raised by Mr. Johnson's QC, Lord Panic, and in the media, and say why they have no relevance.
Casey.
Yeah, Casey. Yeah. Lord Panic Casey. Particularly paragraphs 18 and 19 on, at page, sorry, 70, at page 82, where they talk about whether the committee is performing the role of investigator, prosecutor, judge, and jury, and is it the case that in no other context would this be regarded as a fair or impartial process, and explains in detail why a process that is almost identical to this process is not judge, jury, and execution, and is a fair process. So I'm not going to take the court through that, but I would invite the court to just go through and explain it. So I can then talk about what is the standard for a review of the committee and the National Assembly process. There is a debate in the papers about whether Section 34 of the Constitution applies. They rely on it, we say it's not applicable. It doesn't really matter, I don't think the court needs to go there, because the governing standard is Section 12.3, which says the process must be reasonable and procedurally fair. So that's a standard that Parliament set for itself in the Privileges Act. Of course, it must also meet the requirements of legality, it must be rational, but that's a lower standard. So the real standard is reasonable and procedurally fair. But there are two factors that this court must also keep in mind when applying that process. The first is the one that my learned friend referred to, is that Parliament is not a court. And he took you to paragraph 44 of the Lord Law EFF judgment, which explains you cannot expect Parliament to act like a court. If you expect Parliament to act like a court, one of two things is going to happen. We're either going to have processes that are so long, like the public protective process, that it's unable to do its work, or it is constantly going to be acting unlawfully because it cannot meet the standard that's been set for it. So that's what happens if you say to Parliament, you must act like a court, you must analyze evidence like a court, you must apply the rules of evidence, you must apply the rules of discovery, you must record all your things in the way that a court would record its judgment, otherwise you haven't done your job. It's unworkable and it's not what the Constitution requires. The other is, Parliament absolutely accepts that this court can review its process.
Yep.
But the separation of powers is still important. And there must also be a degree of deference to the way that Parliament regulates its own internal processes. And I'd like to refer the court particularly to the judgment of Doctors for Life, which I'm sure that the ladies are all well aware of, and particularly paragraph 37 of that judgment.
Which one is this, sorry, Mr. Bishop?
Doctors for Life.
Oh.
The reference is 2006 6 SA 416 CC.
Is that here in your...
It's not, unfortunately.
Okay, so just give me the reference again.
2006, volume 6, SA 416 CC.
At?
Paragraph 37.
Is this a judgment just in Kobo?
Yes.
That one, yeah. Okay,
Yes.
got it.
In the public participation.
Yes, very important.
And so what he says is the constitutional principle of separation of powers requires that other branches of government refrain from interfering in parliamentary proceedings. This principle is not simply an abstract notion. It is reflected in the very structure of our government. Courts must be conscious of the vital limits on judicial authority, and the Constitution is designed to leave certain matters to other branches of government. They too must observe the constitutional limits of their authority. This means the judiciary should not interfere in the processes of other branches of government, unless to do so is mandated by the Constitution. So, if Parliament has acted unreasonably, procedurally unfairly, this court must enforce the Act and tell it it has done so. But in assessing what Parliament has done, and in applying those standards of reasonableness and procedural fairness, it must also give some leeway and deference to Parliament to determine how best to regulate its own process. And only if it's strayed beyond those realms. So it's not enough for this court to say, well, I would have granted that postponement. That's not a basis to interfere with what Parliament did and the way it regulated its own process. The final, before I get to each of the grounds, to emphasize this, what's very interesting in this case is that if you look at all the review grounds, none of them say, but we're not guilty of contempt, or the requirements in section 12.9 for suspension were not satisfied.
Oh.
Those are not grounds of review. The grounds of review are all procedural nitpicking.
Procedural only, yes.
And I don't need to take you there, but the point is made in the answering affidavit, page 342, paragraph 29.
3.
Page 342, paragraph 29. So against that background, I'd like to turn to the grounds of review, and I'd like to do so by referring to the founding affidavit, because the applicants are bound by their founding papers. They cannot advance review grounds that are not in the founding papers as review grounds. And so I'd like to start at paragraph 198 to 198 of the founding affidavit, which is at page 66. So this is where the heading is the impugned decisions and actions. And then they say in 197, the disciplinary processes to which the applicants were subjected contain manifestations of each of the unlawful and unconstitutional features of the MA rules highlighted above, as well as some other blatantly unlawful features. And then they list first, second, third, fourth. So the first one is a complaint about bias. It says the committee was made with a large majority of our political opponents. I don't intend to deal with that. Mr. Nasseruddin has dealt with that.
Yeah.
If the challenge to the rules fails, then there cannot be a separate review ground based on bias. This isn't a different type of bias that they're alleging here. It's the same bias. They're not saying, well, in particular, Dr. Latreat on the committee was biased because X, Y, and Z. It's not that. It's just the same institutional bias complaint. So that's the first review ground. The second one begins at paragraph 202 and 203. And what's pleaded is the lack of clarity on the requirements and standards meant that we were not able to demand certain accommodations, such as the CCTV footage from a better angle, and we did not know what standard of proof the initiator would have to meet. Had we participated in the hearing, our legal representatives would have been at a serious disadvantage. So it seems that there's two legs to that. The one is about the standard of proof, and the other one is about accommodations, particularly access to CCTV footage. The answer to the standard of proof is really the same one that Mr. Nasseruddin gave to the attack on the rules, which is that these are not judicial proceedings. They are inquisitorial proceedings in which Parliament and the committee do not apply a standard of proof or rules of evidence in the way that a court would. And there's nothing wrong with that.
It's not accusatorial.
Exactly, my lady. It's not an adversarial process, it's not an accusatorial process, it's an inquisitorial process. Much like a tribunal under the JC Act, the JCT tribunal, my lady presiding, appearing on one, that's what the courts have said about those types of procedures as well. And that's, if one looks at the Boris Johnson report, that's also what the committee there says about their types of process. So there isn't a standard of proof, and the absence of one stated in the rules or applied in this case doesn't render the process procedurally unfair. Then we get to the CCTV footage. And it's important to be clear about what actually happened here. So there was a letter was written by the applicant's attorneys to the Speaker asking for the CCTV footage. And the Speaker responded in a letter from the State Attorney on 12 November 2023. And the relevant part is at page 141 of the record, paragraph 21, where the Speaker refuses to provide that CCTV footage.
Yeah.
But there's no review of the Speaker's decision. That decision was not reviewed before this court. And the Speaker's decision did not bind the committee. And the committee never took a decision about the CCTV footage.
Oh.
Because what happened, my learned friend sounds surprised, but this is said expressly in the answering application. What happened is there's an application for postponement. One of the reasons for the postponement is that they want the CCTV footage. Other reasons are given as well. The postponement is refused. The committee never says, and we are refusing to give you the CCTV footage. They refuse the postponement. And then the applicants leave. They say, we're not participating in this process. And so they never ask the committee, saying, okay, we can't get a postponement. We're going to go ahead with the process. We need the CCTV footage. We need the subpoena of the president. We need the subpoena of the speaker. Either now, before Mr. Tasso gives evidence, or later so that we can present our case. So that's a very simple answer to the complaint about the CCTV footage. The other answer is, it is so that the initiator, who's not the decision maker, Mr. Katz, he doesn't take the decision for the committee, argues that the CCTV footage would be irrelevant. And he's probably correct about that, but the issue was never determined by the committee. The next ground of review begins at paragraph 204 of the founding affidavit. And so this is, again, a complaint about discretion for penalty and whether the committee, in fact, considered section 12.9. So, again, there's two parts to it. The one is there needs to be clearer guidelines on sanction. Mr. Nasseruddin has dealt with that in the challenge to the rules. I'm not going to repeat it. The other is that section 12.9 was flouted without any consideration given to it. So the claim is that the committee didn't consider whether those two requirements of severity or repetition and that no other sanction be appropriate were met. And so that's just not the case. If one goes through what happened before the committee, it's clear they were very aware of section 12.9. So we can begin with the initiator's address on sanction, which begins at page 740 of the record.
Just give me that page again.
740. 740. And what Mr. Katz does in his address is he says, let me go through each sanction in section 12.5 A through G. And he goes through each one.
Sorry, which page is this now?
It starts at 740.
740. Okay, carry on.
Until 741.
Yeah.
And he goes through each of them. He says why, in his view, each one is not is appropriate for the apology and the suspension, and the others are not appropriate. He also, at page 742, explains why, in his view, this is a serious form of contempt, warranting meeting the requirement of section 12.9a. So both of those, that other sanctions are appropriate and that this is serious, are addressed by the initiator to the committee. And then at page 743, Mr. Katz seems to have almost forgotten to expressly mention 12.9. But he does. He says, excuse me, there is one more. Oh, yes. In order to do so, in order to impose a sanction that is set up in section 12.5g, the committee would need to be satisfied by virtue of section 12.9a that two issues are at stake, and he deals with each of them specifically. So that's what the initiator says to the committee before they deliberate on sanction. And then if one looks at the committee's deliberations, I don't want to take you through, I'm just going to give you the relevant references, but if you read through those deliberations, they consider both the options, whether other options are sufficient, and some of them propose other options. Some of them propose a fine, some of them but there's another proposal that's put up as well. And they also explain why they consider it severe. They give their reasons why this was a severe form of contempt and why a message needs to be sent to other members. So it's expressly considered in the deliberation. And then most importantly, it's in the report that goes to the National Assembly. And that's at page 788. Sorry, it begins at 786. Where they're dealing with sanction. So 786, paragraph 2. With respect to aggravating factors, the initiator drew to the attention of the committee to the relevant provisions in the Act, namely 12.1, 12.3, 12.5, and 12.9. And then deals with what the initiator submitted and ultimately the sanction is reached. And the sanction is expressly imposed in terms of section 12.5G, read with section 12.9. So the committee was fully aware of what the requirements are. The complaint seems to be that what didn't happen is they didn't write a judgment in which they sort of expressly set out 12.9A, 12.9B, these are our reasons why we say they were met. But if one looks at what's submitted to them, what they deliberate about, and what's in the report, they knew what the requirements were, and they determined they were met. And as I said at the outset, the substance of that determination is not challenged before this court. The applicants do not come and say, but 12.9A and 12.9B are not met. This wasn't severe. Other sanctions were appropriate. That conclusion was irrational. They never say that. Instead, they try and nitpick and say, well, we don't see enough reference to exactly the way we would have liked it to be set out to show that they considered it. But when one looks at it, they obviously considered it. And they reached the only rational conclusion. So that brings me to the next ground of review, which is at paragraph 210 of the founding affidavit, which is that the late delivery of the notice constituted an ambush. So this is the same argument about timing and the weaponization of the timing. I didn't hear that separately pursued in oral argument as a separate ground of review. But the argument is, one, it's parasitic on the attack on the postponement, which I'm going to get to shortly. But if the committee was justified in refusing the postponement, then it's difficult to understand why the delay would be a ground for review. Because all it would mean is, well, the only basis the applicants could make that claim is an ulterior purpose claim. To say it was delayed this far for an ulterior purpose so they could impose a sanction at a different time. But that makes no sense, because even if they'd heard this matter in March or April in 2023, they still could have imposed the sanction for the month during which SONA would have been in 2024. They imposed the sanction in November, and they chose February specifically. They could have done that whenever they imposed the sanction, so it made no difference when the matter was heard. So there's just no basis to this idea that the delay was for some sort of ulterior purpose. And my learned friend has given you the references to whether Parliament explains the delay. And shows, yes, it's unfortunate that this took 8 months. It would be better if it took shorter, but it's about internal process around procuring an initiator. And going through those processes, it's bureaucracy.
But it seems as if they seek parity. There should be parity as far as the timelines are concerned.
Yes. I don't think what they're entitled to is fairness. So if they had enough time to prepare it, then it was fair. The fact that Parliament may have had more time doesn't matter as long as they had enough time. As long as they had enough time that they could fairly prepare for it.
Pursuant to what? The rules?
Well, pursuant to the... So the rules set a 5-day...
5 days, yeah.
Yes, 5-day minimum, which isn't attacked. And they were given more than 5 days.
Yeah.
They were given 10 days.
What I'm saying is, if it's 5 days not
8.
attacked, we've got to accept that.
Yes.
Yeah.
Yes. And there may be... I accept that there may be cases which are
You need much more than 5
complicated,
days.
and 5 days would be unreasonable to expect somebody to prepare. I'm going to argue later that for this particular case, given the nature of the charge and the nature of the evidence, and the nature of the papers that were given to them, 5 days was more than enough time, and they had 10 days, or 9 days.
8. I think it's 8.
Sorry,
Yeah.
8 days.
8, yes.
So that deals with their fourth complaint, which is the late delivery. The fifth complaint is then in paragraphs 211 and 212, which is about whether they had a right to be given separate and additional notice after they were convicted in order to make representations on sanction. So, or what they say, refer to section or item 9 of the schedule and say the committee made no attempt to offer us this opportunity. In fact, as stated above, neither our attorneys or ourselves have received any communication from the committee or the NA about the findings and penalties since the morning of 20 November 2023. Where we were told that our application was postponed was dismissed. This argument is really quite disingenuous because they had the opportunity. They chose not to take advantage of it. So it's important to remember why are we even debating this question? It's because they left the hearing. Why did they leave the hearing? The second respondent tells us at page 677 of the record. So this is after the committee refuses the postponement. Mr. Malema explains why he's leaving. And I'd like to read it. This is what Mr. Malema says at page 677. It's very clear that we are being subjected to a kangaroo court, and which we are not going to accept, and you brought this white man here to come and persecute us, because you will know that every white man will go after the blood of the EFF. That's what he's there for. They're talking about Mr. Katz.
Yes, poor Mr. Katz.
I don't care whether my legal representative says he's got respect for him. I've got no respect for him. He's a DA lawyer. He's a well-known DA lawyer, looking for our blood. And then there's an intervention, and then at the end of that page, Mr. Malema continues. So all I'm saying is you brought an apartheid apologist and beneficiary to come and persecute me. No white man can persecute me. I'm not going to allow that, and no white man will persecute you there. And you're not going to accept to appear before this white man and before this kangaroo court. You can go and be together in your own arrangement there. We are not going to participate in this kangaroo court because its outcome has been determined even before by yourself and the DA. That's why you brought a DA lawyer here to come and speak to us. It is not a man of integrity. He has got no integrity to come to persecute us. I will never be persecuted by a white man. We refuse to appear before a white man. We refuse to appear before a kangaroo court. Do what you want to do.
Any application for recusal of Mr. Katz, for example?
No. Mr. Nkatobi, SC, who appeared for the applicants, took a very different view from Mr. Malema.
No, he was very, he behaved in the best traditions of the bar.
Yes, absolutely.
Yeah.
And he accepted Mr. Katz's integrity, that he was doing his job as an advocate.
No, it's very unfortunate that. I'm not
But
sure.
that's-
But we can't hold that against Mr. Malema. He can say what he wants.
I'm not, but those are the reasons. That's why they leave.
Well, could I ask you this? It seemed to me that Mr. Pemed's main point here was twofold. The one was that when you look at Regulation 9 of it, there's a sort of bifurcated approach. He took it. He said, well, there's one thing in relation to, as it were, the conviction, but then there's a must in relation to hearing representation. One. And two, there was a letter from Levitt's attorneys offering, saying we will make representations, I think, within 24 hours. Right?
Yes. So if I can deal with
Isn't it extraordinarily unreasonable not to say, oh, well, all right, we'll hear you in 24 hours?
Well, can I deal
Mr.
first
Bishop, I can't think. I'd be a very rich man if I had a breakfast for every time as a judge I'd said, I don't like this, but I'd rather give you the benefit.
Well, I think, can I first deal with what the schedule means, what item 8 and 9 of the schedule means?
Yeah, that's...
And then I'll deal with
Yes,
the
because I'd
facts.
like you to, because I mean, that seemed to, this is a point
Yes.
of central importance to
Yes.
your opponent's submissions, and I want to hear you on it.
Yes. So let's first deal with what did the rules require.
Yeah.
So you've got to read item 9 with item 8. And so these
All right,
appear on
let's just get there.
Just do
page
that.
81
Yes.
Right.
If I can find
of the
mine.
record.
Item 8 and item 9, yes.
No, 81. 81.
Yes, I'm here.
Yeah. So item 8, if after receiving the notice the member fails without just cause to attend the hearing, the committee may proceed in the absence of the member. Now,
Yes.
there's no dispute, there's no allegation, there's no review ground that the continuation up to the point of sanction without them being present was lawful. So we must accept that there was just cause, and it clearly was, based on what I've just read to you from the record, that if members of parliament wish to absent themselves from a disciplinary hearing because they determine it to be a kangaroo court and they don't wish to appear before or appear in a process where an initiator is a white man, that's their choice, but it's not a just cause in the meaning of
Just give
item
me
8.
the reference again. Sorry, I didn't write down where Mr. Malema provides Mr. Katz with a character reference.
It begins at page 677.
677. Right.
Yeah.
Carry on. So I'm interrupted you. Please carry on.
Yes, that's the first part. So the committee can proceed if you're absent without just cause. There was no just cause here. The committee was entitled to proceed with the hearing.
Yeah, that's where the distinction is made.
There is only
But-
one hearing.
Yeah.
That's the key point. If you look at the whole of the schedule, it never talks about a conviction hearing and a sanctions hearing. It talks about the hearing.
What if then the accused has got a change of heart and say, I want to come back?
Well, let's look at what item 9 says.
Okay.
So item 9 says, if the committee finds a member guilty of misconduct or contempt, the fellow member, legal representative, must be given an opportunity to present mitigating factors to the committee before the committee reports to the House. Such representations may be verbal or in writing. So what's important here is it doesn't say anything about notice. It doesn't say that the committee must give a separate notice to the member. And why doesn't it say that? Because the notice is given for the hearing at the outset. And this is the same hearing. It's the same hearing that's going on, which you've chosen to absent yourself from. All
Are
item 9
you
is
saying that only once you're present at the first stage of the hearing?
if you are
Does it kick in?
if you're present, or presumably if you're absent with just cause, here
Yes.
they're absent without just
Yes.
cause. But if you're present at the hearing, you must be given an opportunity. So you've now been convicted. You're here before me. I must give you an opportunity. It doesn't say, if you are absent without just cause, you've left, you've said this is a kangaroo court and you've gone away, that the committee must stop, issue a separate notice, and give you separate notice of a new hearing, a different hearing.
Which takes us back to the recusal issue, because it's going to be the same committee, the same kangaroo
Yes.
court, is
Exactly. Because there's one hearing. They got notice of the hearing right at the beginning of the process.
But I want
So-
to come. So please carry on.
So that's what the law is. But let's look at the facts. And I want to start with the point you gave about the letter, and then I want to talk about YouTube.
The letter does. The letter 258-259. Is that what you're talking about?
Yes. So we've got to get the timing right here.
Yeah. Yes. That's what I want you to clarify.
On the 20th of November is the beginning of the hearing. That's when the postponement application is heard. That's when it's dismissed. Mr. Malema walks out.
Yeah.
Mr. Klaso gives evidence.
Yeah.
They come back the next day on the 21st.
Yeah.
Mr. Katz makes submissions on the merits. I want to get this correct. I think it's during the submissions on the merits that he says, I've received this letter. But the letter isn't the submissions. The letter says, we want to make submissions. And the initiator says to the committee, well, we're here, we've refused the postponement, we should not wait for the submissions. The committee agrees, reaches a finding on guilt on the 21st. Convicts, for lack of a better word, on the 21st. And this is important. They then hear Mr. Katz on sanction. He makes submissions on sanction. But they don't deliberate on sanction. They postpone it to the next day, to the 22nd, at 11 a.m. It's in the transcript. The
The
chairperson says,
22nd, eh?
we will come back on the
Is that
22nd at 11 a.m.
Yeah.
When they come back on the 22nd at 11 a.m., the first thing that happens is Mr. Katz says, I've received these submissions. We received them overnight, late on
Those
the
are the
21st.
ones promised in the letter from Ms. Cupido.
Yes.
Yes.
But now they've only been received and only presented to the committee after they made a finding of conviction. And they only go to the merits. They say nothing about sanction. And the committee says, on the advice, well, Mr. Katz submits to the committee, you're functus officio, you've already made a determination, it's too late. And they agree and they say, well, we can't look at these submissions because we've already determined guilt. And there's no challenge to any of that. No ground of review for any of that went on.
Could I just ask you this? When Ms. Cupido writes this, and they then do serve representation,
Yes.
that's an affidavit, I think, or some sort by Mr. Malema or something, is that right?
I don't think it's an affidavit, I think it's
Or is it just
submissions, but in
statement?
Mr. Malema's name.
It's called a written statement.
It's a written statement.
Yes. Mr. Malema's name is at the
Yeah.
bottom.
Yes,
But it's
yes.
not an affidavit. It's
No, okay, no, that doesn't matter. Written statement on behalf of the charged members.
Yes.
Yeah.
It's at 243.
Yes.
Are you saying, I just want to make sure, because I did read this, are you saying that if I read these, which I did, just to read them again, there's all sorts of stuff about Mr. Ramaphosa,
Yes.
Which
I mean,
I-
he was threatened.
mercifully we don't have to deal with. the point about it is that, are you saying that all of this, particularly the issue of the protection of the Constitution, they all had to do with conviction?
Yes.
Yeah, nothing on
Nothing to do with sentence.
Correct.
So your submission is, it's all very well, so let me get the sequence right. The committee, on the 20th, Mr. Malema walks out.
Yes.
Basically says he's not prepared to be in front of the kangaroo court. On the 21st, the committee convicts.
Yes.
Right?
That they had, before they convicted, they received the letter, but not the submissions. They received the letter that said, we want to make submissions.
Yes.
So there's that very short letter that said...
All right, so there are two issues that flow.
Yes.
No, they're very short letter.
Yes.
The first is, have they got when Mr. Katz says, I've got to go check this, but you'll let me know so I don't have to. Mr. Katz says, I received this written submission. Is that correct?
So there's two things he says. He says, we've received the letter, which is on the 21st,
Yeah.
for conviction, and they decide that they're going to proceed and make a determination on conviction without waiting for the submissions. Submissions hadn't come in yet.
And that's on the 21st.
That's on the 21st.
And the submissions have not yet come in.
No,
The submissions come in, what, the next day?
overnight.
Overnight. Okay, it doesn't matter. But your point is, therefore, as I understand it, no, we're not waiting for submissions in relation to conviction. You've walked out, you've made your attitude perfectly
Made your
clear.
bed.
Goodbye. Conviction, therefore, follows.
Yes.
Now the argument is, well, why didn't you postpone this to allow the submissions to be made? Your submissions, understand it, is to what end? If you were entitled, if the committee was entitled to say, we waited long enough, we've got our evidence, we're going to convict, the mandatory component, if I assumed Mr. Pramihid's argument to be correct, was about sentence.
Yes.
But there were never any submissions made in that regard.
That's
They were
correct.
only about conviction.
The
That's your submission.
And they were made after conviction.
After conviction.
Yes, that's what I'm saying.
And there's no review ground on that. There's no review ground that says it was unlawful for the committee to proceed to convict despite having received the letter from Mrs. Cupido promising the submissions. There's no review ground on that.
The review ground is about
The review ground is
postponement.
very different. The review ground we're dealing with now is that after they're convicted, as I understand the argument, the committee had to give a separate notice and notify the applicants and say, we have convicted you. We will be convening to debate sentence on the following date and time and place, and you have an opportunity to present.
And your submission is no. If you read 8 and 9
Yes.
together, it's one basic hearing.
Exactly. And there's another submission.
Which means that on your submission, contrary to your opponent's submission, although there's a must,
Yeah.
if you say, goodbye, I'm not going to be here,
Yes.
well, that is a waiver.
So you have notice of the hearing. The hearing runs from the beginning through to sanction.
Just to
If you
sanction.
choose to absent yourself at the beginning, halfway through, whenever,
You can't approbate and reprobate.
you can't then say, well, I'm entitled to a notice because it's one hearing.
I got you.
And so you must be given an opportunity, not you must be given notice. But and this is the last submission I want to make on this point, because it's worse than this. They knew that they were meeting for a sanctions hearing then. Why do we know? Because they tell us they were watching the whole thing on YouTube. If you go to page 40 of the record,
Yeah.
paragraph 85. The conduct of the hearing, which we watched as it unfolded, suggested what we had anticipated. The finding of guilt was a foregone conclusion, and the committee did not deem it necessary to inquire into the events of 9 February beyond the video evidence presenting a slanted and incomplete picture of the events. After watching the hearing, I submitted on behalf of the EFF and the applicant's submissions on the merits of the hearing. They watched the hearing. They say they watched the hearing. What happened at the end of the hearing? If you go to page 744. So this is the hearing of the 21st of November. 744 at the end of the hearing. Honourable members, this is the chairperson. Since we are having, my humble request is we adjourn the meeting and we will resume tomorrow at 11 o'clock so that we finalise our matter. So that is the announcement I am making. And the only thing left was sanction. They hadn't yet deliberated on it. So it was absolutely, the applicants knew that sanction was going to be deliberated 11 o'clock, 22nd. If they wanted to come and give submissions, nothing was stopping them. But now they complain, oh, well, you didn't send me a nice invite in an envelope telling me to do so, therefore your whole process that I think is a kangaroo court is unlawful. That's the argument.
So your argument is they were late with regard to submissions on conviction.
Yes.
The committee took the view, the door shut on that, we're going to make our deliberation on that. Two, the sanctions and the conviction hearing are basically
It's one hearing.
one hearing. Nonetheless, it was postponed to the 22nd.
Yeah.
On their own version, they knew about this.
Yes.
So nothing stopped them, on your line of argument, from saying, hang on a moment, we better actually make submissions with regard to it.
It's a sanction.
And here you are on the 22nd, here's our written statement with regard to sanction.
But they put up a written sanction with regard to conviction. And that's
Okay.
what you could say.
Yeah.
Yes, but what I'm trying to say is,
They
in
could
your
have.
submission, they could have done that, they didn't do that.
They could have come to the hearing and called witnesses if they wanted to.
The fact that they didn't come, knowing that it was taking place, and knowing their general attitude to this,
Yes.
meant that what was the committee supposed to do, I suppose, is your argument.
Stop its work, send an invite and say, we are hereby giving you formal notice. Where in the schedule, where in the rules does it require that?
Yeah, gotcha.
Nowhere does it say there must be separate notice for members who choose to absent themselves from the proceedings.
All right.
That's the point.
Got your point.
So, so that's why there was nothing wrong with the way the committee proceeded. There was no, that they had the right, even though they had absented themselves at the beginning, they had the right to come back. And if they'd come back and they'd been there, or they'd made timely submissions on sanction and the committee hadn't considered them, or they'd appeared in person and the chairperson said, I refuse to listen to you, we'd be having a different
We
debate.
wouldn't have been here now. Okay. Could I just ask you this? You did make a point, they never took it on review. Sorry.
The fact that
They
the
didn't raise-
committee, before they determined conviction, received this letter from the applicant's attorney that said, we wish to make submissions. They said, we're not waiting. They make the determination on conviction. The submissions on sanction on conviction come in overnight. And they say, well, we're not considering them because we're functus officio. There's no review ground to that whole. I don't submit there could be a review ground. I think what the committee did was entirely lawful and reasonable.
Yes, but there aren't.
But there isn't a review
We don't
ground.
have to decide that because there's no review ground on that point.
Precisely.
Got you. Thank you.
And so this is not a case about waiver, whether there's waiver in the formal sense or not. It's a case about two things: whether the committee complied with the schedule, the rules, 8 and 9, and I've made my submission for why it did, and secondly, whether it acted reasonably and procedurally fairly in terms of Section 12.3, and it did. So we don't have to establish waiver. That's not our case. The word waiver might have been used in the affidavit, but our case is not one of formal waiver, and we have to meet that high standard. Although I submit that we could meet it on these facts, given their conduct and given what they admit they knew, that they watched it, they watched the hearing, they make submissions but not on sanction. But we don't have to meet that hurdle. That brings me to the last pleaded ground of review, which is the postponement. And so I want to take the court, unfortunately, back to the founding affidavit, to page 213, paragraph 213, which is on page 70. So there's one paragraph where this review ground of the postponement is dealt with. So earlier in the founding affidavit, they talk about the postponement, the reasons why they asked for a postponement. But this is the review ground. This is what's pleaded as a reason to set aside the committee's and the National Assembly's decision. Apart from the above, the committee should have given the EFF the postponement it requested. The request was reasonable and fair. There was no basis at all to refuse the postponement. The refusal of the postponement on its own is reviewable and is a standalone basis for setting aside of the entire disciplinary process. And so there's two preliminary problems with that. The first is, even if the refusal of postponement was unlawful, that's not a basis to set aside the ultimate conviction and sanction. You've got to plead that because you refused the postponement, that rendered the proceedings unreasonable and unreasonable or procedurally unfair. And that averment is not made. And one can think of many examples when that would be the case. So in this case, we would say, we don't know what would have happened if they participated, but given the nature of the case, the proceedings may well not have been unfair if they participated in it. We don't know because they didn't participate. But if I can think of another example, somebody asks for postponement in a trial because the witness they want to call is not available, and the judge says, no, I'm not granting it. So they call another witness, and that witness goes, and by the time that witness finishes, the first witness is available, and they call that witness, and there's no prejudice. So refusing the postponement may have been unreasonable, may have been unlawful, but unless it causes the proceedings as a whole to be unreasonable or unfair, it's not a ground to set them aside. And that averment is not here. And that's enough to get rid of the postponement ground. But there's another basis. They don't say why the decision to refuse the postponement is reviewable. All they say is there was no basis at all to refuse the postponement. But what are the review grounds? You've got to say to us, these are the reasons that we gave. This is why your refusal to grant the postponement, given what we told you, was unreasonable and unfair. And they never do it. They just have one sentence. So we're left to guess. We have to go back and look at what's said in their initial application, what Mr. Ndlozi said to the committee in oral argument, and guess what, which of these ones do they think are the reasons that were so good that the refusal of postponement is reviewable? And that puts Parliament in an invidious position, because it's got to guess. So it might guess wrongly. It might not address some of the reasons that they are going to rely on, or it might end up making the case for the applicants, because you're trying to cover all the possible bases. And so you end up making a case for them, and that's not fair. The ground has to be properly pleaded. It isn't, and that as well is sufficient to refuse this ground of review. The third submission is that even if this court wants to get into the merits of the committee's decision to refuse the postponement, it's a very high hurdle to interfere with the decision to refuse postponement. It's discretionary. You generally, even in court proceedings, an appeal court will very seldom interfere with the refusal or grant of a postponement. It's for that court, that body, to regulate its own process. And we would say the same is true here. It really goes back to the first submission I made, that a court should only interfere in circumstances like this, where Parliament is regulating its process. It says, we want to get this done, we're going to get it done, if the applicant can show unfairness. And not only have they not shown it, they haven't even pleaded it. But let's assume, contrary to all of that, that this court wants to look at the reasons why the committee refused the postponement, and wants to evaluate whether those were adequate reasons or not, or whether, as they put it, the request was reasonable and fair and therefore had to be granted. Of course, just because a request is reasonable doesn't mean it has to be granted. So, if we look at the reasons that were put forward by the applicants, either in the original application, the written application for postponement, or by their counsel at the hearing, it seems it's the following. The first is the length of time that they had, the notice period that they were given. So they were given 8 days notice. And within those 8 days, they managed to brief senior and junior counsel, eminent senior and junior counsel, who both represented South African International Criminal Court.
For the record, that wasn't me.
Doesn't make you non-eminent.
Not imminent.
Doesn't make you non-eminent.
So they had eminent senior counsel and Mr. Ramachale, excellent junior counsel, who were representing them at the hearing. The record that they were given was, the whole thing was 600 pages, but most of that was copies of the rules, which is about 200 pages, other sort of formal documents. The relevant part is 156 pages. And we attached the index to the record that they were given to show what was relevant, what was not relevant. And most of that 156 pages, I think 90 pages of it, is the Hansard from the hearing at the SONA.
196 pages, 156, I can't remember.
Total is 156 of relevant.
Okay, yeah. And there's
And
including Hansard, yeah.
Yes. And a lot of that, the Hansard is for the whole hearing, I think, up to the disruption.
Yes, also
a lot of that is irrelevant as well. So with respect, it is easily possible to prepare for a matter where that's the limited evidence, plus the video. this isn't a complicated case requiring looking at lots of different documents where lots of witnesses are going to be called, where complicated instructions have to be taken. There's a video, it's a single incident, either you're in contempt or you're not. Come and give your defense. 8 days was more than sufficient. Then there's a complaint about the length of time that Parliament took. I've already dealt with this. That can't render the refusal of postponement reviewable. It's got to be judged separately, no matter how much time Parliament had. As long as the applicant was given enough time, the refusal of postponement was not subject to review. Then there's a complaint about the ongoing litigation, in which so this is the Mdntv litigation, in which the applicants had said they intended to intervene, and which challenged some of the same issues. That wasn't a reason to grant the postponement, both because we know from the City of Tshwane case, so it's the City of Tshwane versus AfriForum, 2016, Volume 6, SA 279, paragraph 74, where Chief Justice Mogoeng says, it needs to be stated categorically that no aspect of our law requires of any entity or person to desist from implementing an apparently lawful decision simply because an application that might even be dismissed has been launched to hopefully stall that implementation. So before City of Tshwane, there were some judgments that went the other way, that said government, when an application is launched, should hold off and give the courts a chance. But since City of Tshwane, it's the opposite. You're entitled to hold back, but there's no legal obligation on you to do so, none whatsoever. And so whether Parliament wanted to take the risk and say, well, we're going to go ahead with this proceedings, maybe it'll be negatively influenced by this ongoing litigation, maybe it won't be, absolutely 100% Parliament's choice to make. And there's absolutely no legal impediment to it doing so. And particularly here, the applicants ended up, they did intervene and then they withdrew their intervention in the Mdntv litigation. So it was never a reason to stop this proceedings. It was an excuse. It was a way to try and postpone the hearing. So then the other reason that's put up is because they needed to get the CCTV footage and they needed to subpoena the speaker, they needed to subpoena the president. And again, there's two answers to this. The first answer is the refusal of the postponement didn't stop them making those requests. All the committee said is we're not granting you postponement. It didn't say we are not giving you the CCTV footage. It didn't say we're not issuing subpoenas. If they participated in the process, they could have asked the committee for both, and the committee would have made a ruling on them. And that may or may not have required a postponement. It may have been that the CCTV footage could have been obtained without postponing. It may have been that the subpoenas could have been issued without postponing. But those two issues, the fact that the postponement was refused, doesn't mean that the committee prevented them from accessing CCTV footage or subpoenas, and so couldn't render the process unfair. Then, none of this, as you'll see from the one paragraph in which this is pleaded in the founding affidavit, has anything to do with the conduct of the speaker during the sitting of the National Assembly, which was what took up much of my learned friend's argument. And as I understand the argument, effectively it's along the lines of, well, we needed to be able to subpoena the speaker so that we could examine her about the validity of her decision on the day to require them to leave Parliament, which then led to them getting on the stage and led to the Speaker adjourning Parliament and led to the contempt findings. And because of the postponement, we weren't able to do so. So the first answer, it's not because of the postponement, or the refusal of the postponement. That's not the reason. But the second reason is none of this is relevant, because we know exactly what the Speaker did. We've got the Hansard and we've got the video. We can see what rulings she made. Those rulings were made and those rulings were disobeyed by the applicants. Whether those rulings were good or bad is not relevant to the proceeding. It's not relevant to the conviction, and it's not relevant to the mitigation. They were there as a fact, and they were disobeyed. Maybe she didn't get the rules right. I've never heard an argument for why she got the rules right. It's just sort of thrown up in the air. We would like to cross-examine her. But on what? On what exactly? What did she do wrong? There's no statement saying, well, this is how she misinterpreted the rules, this is why her rulings were invalid. None of that. It's all just conjecture.
But could I ask you, I think we debated that, the debate shifted to the threatening component. That Mr. Head said, look, the question is whether threatened. Should there not have been an opportunity for the applicants to say, were you threatened or not?
Because of your witnesses' evidence.
Yes.
I think that's right. That's what.
Yes. Well, I think the answers are two levels. One, three levels. We've got to go back to what they pleaded and the grounds of review that they pleaded, and you will not find this argument in their grounds of review. It's sort of they try to sneak it in through their attack on the postponement. Right? So it's an argument that we needed this evidence to challenge the claim that the President and the Speaker were threatened, and the postponement stopped us from getting that evidence. But I've already made the submission that the refusal of the postponement didn't stop them getting the evidence. If they participated in the proceedings, they could have asked for the subpoena, and then we'd have a decision on the subpoena. And then we'd evaluate whether the decision to grant or refuse the subpoena was a valid decision or not. Again, I would say to this court, if we were in that position, that it should give significant deference to Parliament in deciding who to subpoena and not to subpoena. And if matters are only very tangentially relevant to the proceedings before it, and Parliament decides, look, this is at best tangentially relevant, we're not going to waste time and postpone this matter for the days or weeks it might take to get the President or the Speaker here, that it would give Parliament significant deference. But we're not even in that world. We're not even in that world because we never got to the point where an application for subpoena was made to the committee. Because they walked out, because they said it's a kangaroo court. And on the next level in which I'd answer it is, it doesn't seem to me that you necessarily need the evidence of the President or the Speaker to know whether they approach the President and Speaker in a threatening manner. So I think if we go to the charge sheet, it said, you ascended onto the stage without the authority to do so, and in a threatening manner approached the President of South Africa and the presiding officers. So the manner, it doesn't say, and the President and the Speaker felt threatened. That's not in the charge sheet. That's not what they were trying to prove.
In the evidence of Mr.
Yes, but the evidence of Mr. Kaso is also the video. And so one can assess the video, because we have a video of how they approached. And either that was a threatening manner or it wasn't. It may have been very threatening, objectively speaking, but Mr. President Ramaphosa was unperturbed or wasn't paying attention or was looking the other way. That wouldn't change whether
they approached in a threatening manner.
Prove what's in the charge sheet.
Yeah.
So it's utterly irrelevant. Again, it's just they're trying to find really obtuse procedural technicalities to get out of the reality that what they did was contempt and they deserved their sanction, which they never challenged directly. So there's another, despite the fact that the whole case on postponement is about 3 sentences, there's another version of the argument, which is that the committee didn't apply its mind properly. So the argument seems to be that if one looks at the deliberations of the committee and the decision of the committee on the postponement issue, it shows that they didn't apply their mind to all the issues raised by the applicant's legal representatives. So again, that's not permissible because it's not pleaded, so I shouldn't have to deal with it, but I will. And the answer is that it's not true. So first, one has to look at the initiator's arguments, which were presented to the committee. I don't need to take you there, I'm just going to give you the references. It's pages 636 to 653, in which Advocate Katz deals with each of the arguments made by Advocate Nkatovius. And then one looks at the deliberation, which are pages 668, 676. And then one looks at the report, which is at page 781, paragraph 10. And all that, if you look at it all together, yes, they didn't prepare a judgment in the way that a court might, but Parliament isn't a court and isn't expected to comply with those standards. So to say that it didn't apply to mine because it hasn't written a judgment where it goes through each and every reason and provides reasons is, with respect, not what the law requires. But then it gives its reasons in the answering affidavit. In the answering affidavit, which is filed on behalf of the committee and on behalf of the Speaker, the reasons are provided. The retort is, oh, you can't give reasons in an answering affidavit. This is ex post facto reasoning. But that's not how reviews work. Because normally in a review, you bring it under Rule 53, and you say to the government, here's my finding affidavit, here are my initial grounds of review, please give me the record and the reasons, and the reasons for your decision. And then you give your reasons in the Rule 53 record. And unless there's some other statutory requirement that required you to write down your reasons before then, that's the first time you're required to give reasons. And you do it in the Rule 53 record. There's no request for a Rule 53 record here. So Parliament is entitled to give its reasons in its answering affidavit, which it does. And there's nothing inappropriate about that. There's nothing ex post facto about it, because there is no statutory obligation to record its reasons beforehand. So it's permitted to write all the reasons in the answering affidavit. Ladies, I see we have 1 minute left. I need about 2 minutes.
I haven't stopped you.
Not yet.
So that deals with all the pleaded grounds. I've gone through the founding affidavit paragraph by paragraph and shown that none of them have any merit. There were, as I could tell from what my learned friend argued today, there were 2 further grounds that I don't see in the founding affidavit. The first is the failure to consider or decide on whether to refer this to an independent judge or independent legal practitioner. And so the claim seems to be the application for postponement was both an application for postponement and an application for the committee to refer the hearing to a third-party investigator of some sort. And the argument is the committee never only decided the postponement, it didn't decide the referral. This is really, it's pure sophistry. Because how do we know the committee decided it? Because it continued with the hearing and didn't appoint a third-party investigator. So we know what they decided. And we also know that they considered it because one looks at the deliberations, which are pages 668 to 676.
668
to 676. The members of the committee debate this issue and say why they don't think they should have to refer it to an independent third party. So the whole claim, the whole review ground rests on the fact that when they come back after the deliberations and they give the decision, they don't specifically say, and we're refusing your request for referral. They only specifically deal with the postponement. But it's clear that they considered it, and it's clear that they rejected it because they went ahead with the hearing. The last one was which I had done, was in oral argument, my learned friend sought to get some purchase out of the refusal to consider the applicant's written submissions, the ones that came in overnight on the 22nd. I dealt with that.
I think we dealt with that.
Yeah,
We
yeah.
I don't have to go through it again. So those are my submissions on the merits. It just leaves costs.
Follow the results or buy, watch if you win.
I think on scale, I agree with my learned friend that it should be scale C. It's an important matter. In the previous cases, my learned friend was right that we argued for and got punitive costs awards because
Well, that's
the
not on the
conduct was
table,
abusive.
is it?
Yeah.
But I think Biowatch does apply here.
You do.
Okay, that's,
And I think it.
that's a fair concession.
Yes.
I've thought of ways to try and argue that it doesn't, but I can't think of any. So I think Biowatch does apply.
Okay.
And so if the application is successful, the applicants will be entitled to their costs. If it's refused, there should be no order as to costs.
Okay. Thank you. Just have anything?
No.
Thank you very much, Mr. Bishop.
Thank you. Thank you.
How long will you need?
I'm going to ask 10 o'clock tomorrow.
Okay, but how long will you need?
I would say, depending on the level of debate and based on this morning, that could be the entire day.
No,
But
it's not
with
going to
all
be the
due respect,
entire
I
day.
think a reasonable assessment will be I can aim for tea time, but I can
No,
definitely say.
let me put the following. My sister here is in court at 9
And at
o'clock, so
9:30.
I'm going to say we have to start at 10:30.
Okay,
I am more than prepared to give you till 12, which gives you an hour and a
hour and a
half.
half.
But that's it.
I'm indebted.
There's going to be a hard stop. at
Well,
12.
it depends on who can be restrained, my lord. Absolutely.
Mr. You're at our service. 12 o'clock is hard stop.
I'm indebted.
Okay. Well,
So what do we do? 11?
So we'll adjourn
10.
till 10:30 tomorrow
Yes.
morning, just to make that.
I'm indebted
Okay, very good.
before the Erasmus court. So I do apologize to the court for that sort of wending way of the pleadings. But if the court, I'm getting indications that the court is appreciative of how the pleadings are then
Yeah.
going to work. I'm indebted to the court. My Lord Presiding, members of the court, may I just take a step to say the following about the history of this matter? What the court will obviously know is at the time when my clients were suspended from Parliament, there was a single party majority that controlled the structures of the House. That was the ANC. That implicates squarely the principles set out by JAFTA in EFF 2. I don't know if it's helpful to take the court to that in the authorities bundle. Perhaps I can give you the reference. And maybe what we can do is if I can ask the court to take a note so that when the court then looks at this, when it has the bundles, the court will know it appropriately. The relevant paragraphs in the EFF2 matter, which EFF2 matter, citation 2018 volume 2 SA 571 CC, which I will refer to in these proceedings as EFF2, the relevant paragraphs are 192, 193 and 194.
You're too fast there, Council.
I apologize. My lady, what may I assist with, the citation or the...
192
The
pages.
page.
Oh, no. So the citation is EFF and others versus Speaker and others.
Yeah.
Another 2018,
Yeah.
volume 2, SA 571
Yeah, we've got that.
in the Concourt.
Yeah.
Paragraphs 192 to 194, and in the authorities bundle that we will make sure the court has copies of by the end of proceedings, the internal numbering of the authorities bundle we handed up is pages 204 to 205.
Right.
And
This was the case dealing with the question of the motion, the vote of no confidence.
no, that was the impeachment proceeding.
This is the impeachment.
That's the impeachment proceeding
Okay.
case. Yes. And the reason I highlight paragraphs 192 to 194 is because JAFTA J recognized the tyranny of the majority inherent in a committee system that is determined in Parliament by means of proportional representation.
Well, the question I suppose we're going to have to debate is whether the factual context of that particular case is equally applicable here.
With all due respect, my lord, it is the underlying facts of that case are not necessarily directly on point, because you'll remember in the history of that case was at a time when there was no specification in terms of how the Section 89
Correct.
motion
You didn't
is
know
brought.
how you did exactly. There was nothing.
Correct. And what we say is that the principles recognized in the court and the way in which the majoritarian system works in terms of committees applies a fortiori to this committee, because this committee, before this current election that we've just had, was constituted by a single majority. So the principle of the tyranny of the majority, which was prevalent under the Section 89 regime, is as applicable here in the context of how the committee discharges its function. So, here's where the facts become interesting, because with all due respect to our learned friends from Parliament, they invent a red herring case, and then they impose that case against my clients. Because how they construct the case is they say, we want to externalize the entire disciplinary function of the Privileges Committee to some independent senior legal practitioner.
That's not what you're doing.
No, that's not correct, my lady. Why it's not correct is because we say the fact-finding portion of a disciplinary proceeding should be externalized to a senior legal practitioner or a judge or someone of equal status, because that provides an internal check and balance.
There are a lot of jumps in this logic now, so let's just start from let's start from basics.
Yes.
In the EFF2 case,
Yes.
which, I'll read it carefully, you tell me, which will be helpful, as to how you can see what was the problem in that case.
So if we
What
look
was
at
the problem in that case?
If we look, may I just summarize what 192 says, because I think the more helpful paragraphs are 193 and 194.
I'm happy for you to do that, but I still want you to tell me exactly how you read the facts of that case. Let's start there. What was that case about?
I think we've already agreed, Justice Davis, that that case was about how the Section 89 inquiry proceeds in front of Parliament.
Why was there a problem?
The problem is this. 192, the Constitutional Court says, a decision by members of the majority party and the ad hoc committee may prevent an impeachment process from proceeding beyond the committee to shield a president who is their party leader. Surprise, surprise, look what happened in Pala Pala. In recognition of the point that impeachment proceedings are partisan, the acting speaker averred the initiation of such proceedings is inherently partisan, as the aim from the outset is the removal of the president, who will almost always be a leader of the party represented in the assembly.
Yes,
Now,
I understand that, but you see, you're taking this out of context, because have a look at 196.
yes,
I conclude that 89 implicitly to make rules tailored for the impeachment process.
I'm sorry, my lord, could you repeat that?
196.
Yes,
That's what this is all about.
Yes.
What it was about was that you didn't really know, what were
Yes.
the criteria
Yes.
for impeachment.
yes,
Therefore, you couldn't just have some kind of unfettered discretion in
Correct.
that regard.
Correct.
And you needed to have some mechanism.
yes.
Yes.
And-
But that doesn't, non-constat, that means that all of a sudden we can therefore conclude that this is authority for the proposition that when Parliament has to discipline
Yes.
its members,
Yeah.
somehow you use the same logic there. I
No,
don't
no,
see
no.
how that follows.
That's with all due respect, that's placing my client's case higher than what it actually is. Because what my
Tell me why.
clients say is this: is that this is authority for recognition of how the majoritarian system operates in committees on the ground. I accept that what Justice Davis says to me about the fact that that was at a time when the Section 89 process was not clarified in terms of the rules. I'm not suggesting that the facts are necessarily the same that I'm relying on in these proceedings. I
They're
can't.
not, yeah.
Justice Fortain shakes her head at me, and I'm agreeing with Justice Fortain. The facts are obviously not the same.
And
But the po-
therefore,
but-
where does that take me?
but the point is this, with all due respect. Look at what happens after this judgment is handed down and the process that Parliament adopts to vindicate the impeachment procedure. What we know from the impeachment procedure is the first step when a Section 89 motion is tabled is it goes before an independent impeachment panel. And that impeachment panel conducts a fact-finding exercise to reach a position of whether or not the president has a prima facie case to answer, and thereafter hands over that prima facie case to Parliament to run its process in terms of the partisan system which we find ourselves in. That's the point we're making. The point we're making in our case is not that Parliament must lose its ability to discipline MPs. Of course it must have an ability to discipline MPs. But it's about the ability to discipline MPs stemming from an impartial fact-finding mission, which then determines the scope of the inquiry
You see,
and the role to be played by the committee.
That's where the logic is problematic, because in the case of an impeachment inquiry, remember the Constitutional Court said you've got to make rules for this.
Yes.
There's authority that it has to be an independent person.
No, I'm coming there to demonstrate why why an independent practitioner is the most appropriate way
It
to
may
do
be,
so,
but
relying on the
there's no
logic of this
authority in
case.
that case for that particular proposition.
No, there's a novel proposition in front of this case in the context
that's
of
number one.
privileges.
Number two is there a difference between an impeachment of a president and internal disciplinary procedures insofar as members of Parliament are concerned?
We would
Or
say
is there no difference?
No. We would say that with all due respect, engages the wrong question. It's not about the identity of the official who's being held to account. It's the system in terms of which the official is held to account, and whether, if I may finish the submission, that is open to potential abuse by a majority constituted along partisan lines. If I may finish the submission,
yes,
please.
make the submission.
The point is is that Parliament can discipline its MPs, that's fine. But absent an internal check and balance to ensure that it is simply not being done along partisan lines because the power rests with the majority on the individual committee, is where the potential for abuse arises. And may I say this? The way in which you fetter that current unfettered power in the hands of the majority could take the form of an independent senior legal practitioner, or it could take the form of guidelines. If the schedule had enumerated guidelines to say what an appropriate sanction is and how you consider Section 12.9 of the Act when read with Section 12.5 of the Act, then that would have the impact of reducing the ability of the committee to simply run roughshod over everyone's rights.
We'll get there. I'm just simply trying to establish precisely what use I need, speaking for myself, to place on this judgment that you cited. All I'm saying is, there seems to me to be an extraordinary difference between the impeachment of a president, which would ultimately mean his removal or her removal from office, and somebody who's suspended for a period for want of compliance with disciplinary procedures.
With all due respect, Justice Davis, that again prefaces the preeminence of the president as against,
no,
for example...
It's the question, sorry, with respect. It prefaces it's the preeminence of a removal from office.
Yes.
That's a massive step.
I'm with you.
Right? There's a difference between that and saying you'd misbehaved, therefore you are...
No. What the similarity is between the two is it depends on the political influence and the ability of the majority to control the votes on the House.
So your point is simply this, that what this is authority for is the view that if you just leave it in an unfettered way to the members of Parliament, that effectively is susceptible to abuse. Correct. And that's all you say.
It's no higher than that,
right.
because
so
that's the perverse incentive structure.
So let me then ask you a second question, very short-circuit this. This argument's been tried before in front of a full bench of this division.
The Judge Lord was decision.
Cloama, I believe.
Yeah, Mr. Judge Lord.
The Cloama matter.
Yeah. Tell me why that judgment is palpably wrong. Because if it's not palpably wrong, I'm obliged, speaking for myself, to follow it.
In the first instance, Section 12.5 wasn't placed in dispute in those proceedings in the way it is frontally challenged here.
Well, that's very, very dancing on the head of a pin. The fact of the matter is that that court was asked the same sort of questions about bias and majoritarianism, and it found that that wasn't the problem.
Sure, but then the Constitutional Court delivers EFF 2 in 2018, 2 years later after Tlaama, which casts a completely different light on the way in which majoritarianism works in Parliament.
So your argument is that it certainly didn't overrule that judgment.
Did it?
That judgment's still binding on us, unless we say it's palpably wrong. And if it's palpably not palpably wrong, what are we doing here? I mean, that's the precedent.
I take the point.
You've got to tell me now, the one thing you told me is it's distinguishable. Is that what you're trying to say?
Yes, 12.5 and the frontal challenge and the frontal constitutional
challenge. So it would be very helpful if we
them.
got past that point before we got any... Would you agree with me that if you can't persuade us on that, then that's the end of it?
Insofar as the constitutional relief is concerned, yes.
Yes,
insofar as the review relief, the review relief is separate. Yes.
Now, only in relation to your prayers with regard to the constitutional relief.
Yes.
We have to find, one, it's either distinguishable, or two, palpably wrong. Would you be... I'm just trying to get the menu, that's all.
I accept that.
And that's where we want to start.
Yeah. Yes.
Okay, so let's have a look at that.
Yes.
I want to just get my judgment.
Can we look at that copy of the amended notice of motion
that
I handed out?
Yes, please, absolutely.
Thank you.
I just want to get there. Oh, sorry.
It starts after paginated page 3 of the filing page.
Drowning in paper. Yeah, sorry. Please carry on.
So it starts after paginated page 3 of the filing sheet.
Yeah.
There are about 4 or 5 pages which have been struck through because that's part A.
Part A.
Yes? And now we're in part B.
Yeah. Paragraph.
Paragraph 6, starting under part B.
Yeah.
So On the question of whether, if Cloama is binding on this court, what would it strike against? It would potentially strike against 6.1, because that's the impartial fact-finding mission, bias, majoritarianism, constitution of the committee.
Absolutely.
Yes, yes, yes.
Okay? 6.2 is open for me to argue, because Cloama didn't deal with absence of guidelines in the context of sanction.
Okay. We'll hear them.
Section 6.3 is still open to me because those about
Paragraph
6.3, I apologize, my lady,
Yeah.
because those are about fair trial rights, specifically in the context of the right to cross-examine witnesses, discovery of documents, and standard of proof. 6.4 is still open to me because that's about a time bar. So if Cloama is against me in the way that the court positions it, fine. I'm potentially in danger on 6.1. But my answer is 1, distinguishable, 2, EFF 2. But
So-
if the court's against me, then 6.2 to 6.4 are still there.
So the substantive point is this, your submission, is that on 6.1, unless we find the judgment to be palpably wrong, that's it in relation to 6.1. Well, it must be.
If we don't, then it's
Unless you determine that it's distinguishable. Because remember,
Well,
I raised
don't see how to
distinguishability as a
possibly-
second leg of the argument.
Well, reading that judgment very carefully, that is the judgment Justice Lordlaw, and by the way, on that Justice Bozalek agreed, therefore the question
Yes.
is, I don't see how you can. Because he talks about Rule 2, he talks about the fact that you can't delegate.
Yes, but
That's absolutely clear.
with due respect, there is no square answer on the frontal challenge then, because if you read 6.1 about the disciplining and independence, and then go over the page to 7,
Are you submitting that it's different?
yes,
Let's see. Look at paragraph 21 of Justice Lordlaw's.
Yes.
Tell me where on earth one can take a different. Of course you can.
which one? Oh, you have a copy of my bundle, I don't.
Thank you, Mike.
Thank you, Mr. Bishop. My Lord, yes.
Prepared, I would call that. Wouldn't you?
I beg your pardon?
Well prepared, I would call that.
Yes, and especially because it's my client's authorities bundle that was handed up,
Yeah,
which
really.
allows him to be so well prepared. So I take all the credit for that.
Very good.
Justice Davis, we were debating
Paragraph 21.
paragraph 21.
No, I just tried to sort myself out. That's fine.
Yeah, so oh, Justice Davis, may I?
No, you carry on. I'm
Oh.
listening to you.
Sure.